The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
All right, everybody, welcome to day 7 of the Zach Hughes trial. So I decided to do a little throwback hat. This, for some of you that might have been around at the beginning of this channel, this was the first hat that I ever came out with this time last year, because we're coming upon the year anniversary of when we got monetized. Fortunately, that also is the year anniversary of when we lost one of the co-founders of the channel, my father. So that's coming up soon upon us. So I thought, you know what, I got back into the little nostalgia stuff that I have from the beginning when we started out, and thought I'm going to wear that today. So anyways, today we're going to do some, we've got lots to update before we get into court. Court starts at 11. The jury's active. I'm going to go over what's been going on in there. We're inside the courtroom, according to the blog. The things we don't get to see, because we don't get to see what the jury doesn't get to see. And then we're going to go over what this looks like for Zach Hughes, what he's admitted to. We're going to get to see the cross-examination today, if any. I don't know if the state's going to cross-examine him, because I think if they do, it opens up the opportunity for them, or for him, to continue to talk about the things the state doesn't want him to talk about. And in reality, he's admitted to everything. So what is there really to cross-examine him on? Unless you want to open up the possibility that he's going to keep responding with the things they don't want to have talked about. So, but we're going to go over what are the outcomes here for him with what he's brought to the jury. And it appears, based on what's being discussed, that once he gets done on the witness stand, this thing is going to move very quickly to the defense resting, jury instructions, closing arguments. Maybe we have a verdict today, maybe a verdict tomorrow. Should be very, very interesting. We're going to get into all of that here before we get into court. But there's a huge update right now in the case that happened yesterday. John Mello, as everybody knows, was arrested yesterday at 1:30. Now, he appeared in bond court last night at 9 o'clock. So I'm going to show you guys bond court, or a news clip here on the latest with John Mello. Let me get this queued up here, and we'll watch the latest with him. So this is courtesy of Fox Carolina, and here we go.
To a complex upstate murder case, John Mello is charged with solicitation to commit a felony and accessory before the fact of murder. Mello's arrest comes just hours after shocking testimony in the Killing on Canebrake trial. Now, we've been covering it for you closely here at Fox Carolina News. And today, inside the courtroom, the man charged in the murder took the stand.
Zachary Hughes testified that Mello offered him money to murder Christina Parcell.
I told him, John, there's no amount of money that would ever tempt me to do something like this. And I told him I was insulted that he even thought that would be something I would consider. So I told him I would never do something like this for money. I told him the only way I would ever consider taking action like this is if I was absolutely convinced that his daughter was not only in danger, but that the only way to rescue her from that danger would be to take Christina Parcell's life.
Walking you back through this case now, it all started in October of 2021 when Christina Parcell was found dead in her home on Canebrake Drive in Greenville County. Parcell was stabbed more than 30 times. It was about a month later, investigators arrested Zachary Hughes and charged him with Parcell's murder.
And as we mentioned, Mello was arrested today after Hughes' testimony appeared in bond court just minutes ago. Mello shares a child with Parcell and was previously accused of conspiring with Hughes to harass Parcell. The relationship between Mello and Hughes has been a huge focus of this trial. And tonight, Fox County's Alexa Urbach is live at the Greenville County Detention Center, where Mello just went through bond court there. And Alexa, you've been able to speak with some people who are there in attendance tonight.
That's right. So John Mello, as you said, was just denied bond about only 15 minutes ago right here at the Greenville County Detention Center. One of the people in attendance at tonight's bond court hearing was Christina Parcell's sister, and she brought with her Christina Parcell's ashes, telling us that her sister deserved to be here this evening. Also in attendance tonight is John Mello's and Christina Parcell's daughter's former ward who took care of her a little while back, as well as a friend of Christina Parcell's sister. Now, during tonight's bond court hearing, I can tell you that John Mello was looking very calm when he was listening to the judge as the judge read him his rights, while Christina's sister was holding back tears the entire time. Now, his charge of accessory before the fact to a felony is considered a violent crime, so he was denied bond. Because of that, he'll see a circuit court judge in the next 30 days. Tina Parcell, Christina Parcell's sister, again, who I said was there, also took to speaking to John Mello, and she had a very passionate speech. Take a listen.
With my family, with your family. You did this to your family. Your child has to know that you did this to her family. I don't know where I will be when you go to trial, but I assure you, if I am at all capable, I will be there every day. When you are convicted, I will be there at every parole hearing. Everyone. You will never get rid of me.
Now, all of this started after Zachary Hughes took to the stand and delivered his testimony earlier today. And it was around 1:30 that John Mello was arrested from his home along Blake Street in Greenville, soon after Zachary Hughes' testimony. A deputy was seen removing items from his house. I was able to speak with a couple of neighbors who say they were shocked to learn about Mello's arrest.
It's so crazy. I mean, we walk by that house all the time, almost every day. So it's a little scary, kind of crazy.
It's shocking. It really goes to show you never really know who your neighbors are. Like she said, we walk by there every day. It looks pretty ominous. It's a pretty quiet neighborhood for the most part. And then, I mean, every once in a while something like this happens, but I don't think we're any immune to it like anyone else. So, I mean, getting crazy.
Yeah, but we definitely didn't know. We weren't keeping up close enough to know that he was only a couple houses down from us.
Other neighbors telling me throughout the day that they had no idea John Mello actually lived on Blake Street. So it came as a shock to a lot of people in this very quiet, small neighborhood. Coming out from here, I do want to say there was a lot of emotion inside of this bond hearing as it was going on. I was actually standing right next to Tina Parcell. Again, this is Christina Parcell's sister, and you could really feel that energy as she was holding back that tears, waiting to give that very passionate speech that you heard a clip of just moments ago. I'm going to bring you the latest as it comes in, but for now, reporting live in Greenville County, Alexa Urbach, Fox Carolina News. So John Mello is
All right, so there you have it. That is the latest. John Mello denied bond last night at a bond hearing. Christina Parcell's sister shows up, gives a very spirited speech to John Mello, which he had to listen to. So in all of this coming because of the testimony we sat and saw yesterday, where Zach Hughes said that John Mello offered him money to unalive Christina Parcell's, and that ultimately showed him information with the intent to get him to do this. So you can tell the state, the authorities down there in South Carolina, they're double downing on this whole scenario. They clearly don't believe that Christina Parcell's was causing harm to the daughter, even though, interestingly enough, the daughter was going to be the one testifying. Again, I don't know any of this stuff. I don't know what the truth is or what the truth isn't. I just know that it's very, very interesting that you've got the daughter willing to testify against the man who unalived her mother. Now, what's been going on in court? Let's review this here. We're going to go and get that pulled up here. Give me a moment. Let's get the blog up here, and I'll show you guys what's going on. So we will pull that up, and then we're going to have a little discussion on the impact, the possible defenses that Zach Hughes could have. So here it is. Judge started off the day going over the charges ahead of the jury arriving. State asked the judge to eliminate the language of malice. The state requests that if the judge does not want to eliminate the word malice, then it should be amended to without lawful cause. The state argued that the defense is continuing to attempt to get allegations against Parcell in front of the jury. The defense argues they are trying to show the state of mind Hughes was in at the time. And to me, that is relevant. And that is a relevant thing. I think that should be allowed before the jury, which is, and since he's willing to testify, he should be allowed to state it. And then the state, however they want to respond to it, can respond to it. Or they can argue that it's ridiculous, or that, obviously the state clearly doesn't think this is something that they're concerned with. So, let him say what he needs to say. Let him say what he needs to say about how he did it. And we're going to get into some of the ways that, again, just because he's saying what he's saying on the witness stand, it doesn't mean it's going to help him in the end. The defense submitted the jury instructions as a court exhibit. The defense is objecting to parts of the jury instructions. The first objection was over instructions to find guilt. The defense asked the judge to amend the instructions to add until and unless you reach a verdict, or that not guilty be added. And then the second objection was from the defense, was over the example included in the section on malice. And the defense asked that the example is removed. The third objection comes from pages 17 to 18 and is over the definition of harassment. So next, give me one moment, guys. Sorry, guys. So the defense asked that the judge removes the word victim from the definition of harassment. The defense says that the word victim is not used anywhere else and that they would like it removed because they believe it is a legal presumption. The defense then asked that the language under the harassment second degree charge on page 18 be changed from saying if the jury finds the defendant not guilty of first degree, they may find the defendant guilty of second degree, to telling the jury that they may consider the charge. The judge granted this request, and we'll look at the others. So then a break was taken. So it looks like, again, what can we take from that? And that is, they're talking about jury instructions. So it seems that we are very close to getting this thing to a jury. I don't think the state is going to have rebuttal witnesses. Maybe they will. I don't know. But they really can't, because they can't discuss the things he brought up. And if they do, it'll trigger his ability to go further into it. So now we just have the cross-examination. What that will look like, it's going to be very interesting. But what we already have here is enough that it belies discussing what is next. So first off, a couple people I want to say hi to. Wendy Do, thank you for stopping in this morning. And Elsie Wu, or is it? Yeah, Elsie Wu. Thank you for coming in. I appreciate that you agree with me on this. But with that out of the way, we're going to go over some information here. So I prepared a little slideshow. So first, legal defenses that could lead to a full acquittal and this is what we're going to go over. So how can what he testified to be used by the defense? Is it going to be full jury nullification? Is there any defenses out there? We're going to break it all down. So the definition in South Carolina self-defense allows a defendant to be found not guilty if they were not at fault in creating the situation, had a reasonable fear of imminent death or great bodily harm, had no duty to retreat, which South Carolina does have a stand your ground law, or used only necessary force to prevent the threat. So do any of those apply? There is a problem, and there's no evidence that there was an imminent danger at the time of the act, which South Carolina law requires. So the workaround would be is if Christina Parcell was actively harming a child, his defense could argue that he acted preemptively to prevent serious harm. The problem is she was at school. So that is why there was all these arguments outside of the range of the jury, outside of the cameras. And the judge ultimately said, well, there's a problem here. Self-defense as justifiable legally, from a legal definition, cannot be used because she was at school. So that's a problem. That's a problem for the defense. So the first one is out, technically is illegal. So the next one that we're going to have here, let's go over the next possibility of how he could use this. That would be defense of another. Now there was a hearing, and this is an extension of self-defense. So the definition is South Carolina law allows the use of deadly force to protect the third party. This is what his defense was going after. So the defendant has to have a reasonable belief that the third party was in imminent danger of being harmed. The force used was proportional to the perceived threat. The defendant has to have no duty to retreat if they are legally allowed to be there. So can he use this? Is this usable? Well, there's a couple problems with it. He's got to prove he genuinely believed Parcell was an imminent threat to Ada Mello. However, the threat must be immediate, not just potential, and it can't be speculative. And the prosecution argued that Hughes wasn't stopping an act of crime, but was instead acting on assumptions and emotions. And on top of that, she was not present at the time, and she was at school. So, again, South Carolina law does not allow preemptive deadly force just because someone believes someone might be dangerous in the future. So the fact that he had to have known that she was actively doing something to the child, at the moment that he decided to do this. He could not go over there because he thinks in a week, in a day, in an hour that she was going to do something. Some sort of harm had to be happening. And that's why the state put on, of course, early on in their case, that she was at school. That's why we heard that testimony from the school resource officer. Because, again, when you're in trial, the state, and again, this is going on in the Simontilli trial as well, where people are wondering, why are they being so thorough? Why are they putting these things? Because there's things they're anticipating the defense could raise that if they don't cover it, the defense can raise it, and it would put the state in the position of having to scramble to cover it later. So they're just going to cover all the bases. And they did that here. That's why they had the testimony about the school resource officer. Now, so that's out, right? Next is the necessity defense. This is a lesser evil justification. So the definition of the necessity defense argues that a crime was committed to prevent a greater harm. So in this case, you would think, okay, this kind of matches. So what does he need to prove to use this defense? The harm avoided must be greater than the harm caused. The defendant must have had no legal alternative to prevent that harm. And the defendant must have acted immediately, not based on a future prediction. So if Hughes had direct, undeniable knowledge that Parcell was harming a child and that law enforcement failed to act, this could apply. The problem is there's no immediate harm, and there's only speculation based on his beliefs, based on what he testified to. So this is a rarely accepted defense, especially in homicide defenses, unless there was a life or death moment. So, of course, one of the biggest things here is the judge having to assess in the use of this defense, and the jury would have to assess that what she was doing to the child outweighed having to take her life? Was there another way he could have gone about it? Now, what the defense is going to say and what didn't get to the jury is that law enforcement, there were complaints made by law enforcement. There was investigations done previously of Brad Post and Christina Parcell, and things were unfounded. This is why this is the defense they're aiming towards, potentially arguing to the jury. And again, we're going to get into probably how they're going to do that. That's going to be coming up here shortly. But the fact that he was saying that in his mind, he had dealt previously with Child Protective Services in South Carolina and felt they were ineffective. There had been previous investigations. And in fact, Bevel, that was what was brought up on the witness stand and why they tossed the jury out of the room. Bevel had previously investigated claims, found them to be untrue. And then after this happens, they find a hard drive showing that Brad Post did, in fact, engage in inappropriate conduct with the daughter. But this isn't allowed to come in. And if Parcell would have been alive, it's possible she might have been facing charges herself. But again, she's already passed away, and it was in the investigation of this crime that evidence was found, eventually showing that Bevel's investigation was apparently flawed, and he didn't find the evidence he needed to find to move forward. So this is, I think, where they're going to kind of gear towards, but they're not going to be able to use this fully, and they're not going to get an instruction on this. So none of these defenses will be instructed to the jury as usable, and that's important because the jury is going to be told on the law. Now, what we got to look for is the next slide. I believe it's the next slide. And that is, would this be a legal defense or a jury nullification defense? So if the jury fully acquits Hughes, it would be likely jury nullification, not a standard legal defense, is what they would be basing it on. So let's get into what jury nullification is. I did a whole thing on this for the Mangione case. What's jury nullification? Jury nullification happens when a jury chooses to acquit a defendant despite clear legal guilt, usually because they feel the law is unjust or the defendant's actions were morally justified. So could this happen in the Hughes case? Well, let's look. If the jury sympathizes with Hughes' trauma and protective instincts, they might do that. They might ignore the law. If the jury doesn't trust the prosecution's version of events or believes Parcell was truly dangerous. Of course, one of the problems is there isn't a lot of evidence that's come in besides just his testimony. The judge will instruct them to only follow the law. So a full acquittal would be an emotional decision and not a legal one. The most likely legal outcome that we can predict here, full not guilty is not likely, right? That is probably the least likely. It's unlikely unless, jury nullification is the way this would happen. None of the standard defenses will fit this case. They will not be instructed to the jury. So the jury would have to come up on their own with those defenses, and they're not going to. So would a lesser conviction happen? Is this jury? I think that's what the defense is gearing towards, because what they're hoping right now, I think, is that they're going to trigger potentially that they're going to be triggering a defense or the jury to possibly think to themselves, hey, you know what? It doesn't make sense that a trained contra pianist with a contract on a cruise ship coming up just completed a very high-profile project on doing Beethoven sonatas. And on top of that, he's already kind of let some cats out of the bag during his testimony. You know what? This guy there's more to this thing. So we're going to ask you to not convict him of first degree. We're going to ask you to convict him of a lesser deal here, to say, listen, maybe this wasn't the best thing to do. Maybe this wasn't the best way to handle this, but it's how he chose to handle it. And as a result, give him something lesser. Give him manslaughter. Give him involuntary manslaughter, which we're going to get into here of what those possibilities are. So let me turn to the audience here. Let's see here. We have a couple people that have joined us. Tamara, good morning. Deanie Cole, good morning. Deanie Cole Holland, thank you for coming in. And yes, Deanie, if you rewind back, I actually played a news clip from about the hearing and what happened there. So check that out. It's from a local news Wendy Do, I appreciate you as well. Thank you very much. I thought this would be helpful today because this is one of those cases where it's going to be very helpful to kind of have a little idea of what we're watching as we go forward, because this is a little bit of a unique one and this is complicated. Defense rest, Jody, welcome. And Jody is celebrating 3 months of celebrates 3 months of membership. So thank you, Jody. And thank you, Deanie, as well. That brings to mind you became a member this month as well. So thank you very much. So appreciate all of you. Now let's get back to the slide here. So what lesser convictions are they going to be able to consider? Compromise might be included, as I mentioned. Voluntary manslaughter if they feel Hughes acted irrationally but not maliciously. Now, plea deal, I don't think a plea deal is coming. They could work something out at this point. It's still possible. And with Mello's arrest coming, maybe they would come and say, you know what, let's take this out of the jury's hands. I don't think it's probably likely, but it could. The defense is going to probably frame him as, again, remember, he's talked about his childhood trauma. That is now evidence. So at a very minimum, the defense is going to leave the jury with the potential to say, listen, let's say you don't believe she did any of this, but we have a guy who is the boogeyman in this, John Mello, and he preyed on a guy who had prior childhood traumas, who then decided to act in a way that was completely outside the bounds. And as a result, should we punish him with first degree, or would it be better off maybe giving him second degree, maybe giving him manslaughter? But of course, the problem is that if an innocent person died, but I think maybe the jury might be, if the jury, might in this case give him second degree. Who knows? But again, this is a complicated case for the defense because, you've got the jury right now is just hearing these things they're not supposed to hear. So what are they going to do with it? I mean, all they have in front of them is all this evidence that was just presented that without all of this drama, looks like you've got a cold-blooded guy who went and killed her. Now, it does belie the question of saying, why would he do this? Why would he give up his life? And why would he do all these things? So I don't think they're going to opt for involuntary manslaughter. I think that would be extreme. I think we might get a voluntary manslaughter situation. That might be an alternative, but I think if I was going to say, if the jury for some reason really strongly believes that she was harming her child, you might get down to voluntary and say, well, you know what? He acted in a way that was extreme, but he did it to hurt this child, but he did it intentionally or to protect the child. And maybe they land there, but I don't know. I think it's going to be difficult. So the most likely outcome, legally, there's no clear-cut self-defense. There's no protective justification. The only way of acquittal, full-out acquittal, will be jury nullification. But the most realistic outcome, in my opinion, as I just said, is manslaughter. I kind of jumped the gun here before I got to the slide. But to do that, the jury is going to have connected with Hughes on the stand. So ask yourself that question as you review the testimony, and I'm putting it out right now. You can see the entire testimony is coming out should be out by noon. You can review all that testimony, and it's got helpful tags, got helpful timelines, and helpful information for you to understand the pieces and parts that you're going to see. But if they connect it with Hughes and they believe that he legitimately feared for Ada Mello, it's possible they could go to the extreme and acquit him. But I really think it's going to be difficult because of the limited information they have. But I could see them going reduced. That's why I said I could see them going to a manslaughter potentially, depending on how this cross-examination goes. But the only way this gets to this would get to a full acquittal is jury nullification. There's no justified legal reason to acquit him fully other than jury nullification, at least, because they're not going to get any instructions that's going to give them that route. So this is going to be, now what I'm looking for here is, will the defense ask for a jury nullification instruction, which all that does is it lets them know that it's possible. Like I said, there is case law out there to support it. In New Hampshire, it is now passed by the New Hampshire legislature. It is now law that if a defense wants to ask for it, it can be a part of the basic jury instruction packet, and it just says it's available to them, that they have the right to do that. It also gives them a disclaimer that says it's not right either. It's not what, they shouldn't do that, but they can do that. And it's a right that every juror should be aware of. Now, in New Hampshire, they were famous because there's a case up there that was a marijuana case, a Rastafarian marijuana guy who, for religious reasons, grew marijuana, and he put it before the jury, and he won the case. He won the case on jury nullification, and he got a jury nullification instruction out of that. They gave it to him. So it can work. But for an extreme case like this, I think anytime somebody shows their willingness to take a life, it is concerning, right? Having that person walk among us. And if he was able to be manipulated, holy cow, and then goes in and does this extreme action, he's a dangerous person. While he might have done it on good pretenses, you don't want somebody who's willing to just do this like this, and for no reason. So it looks like the judge just entered and the jury just entered for today. So it's 11:07. So 11:37 is when we will see our feed come back up. So it looks like they're going to continue now with the cross-examination. Hughes is back on the stand as we're following it. So we'll see what happens with this cross. Like I said, it's going to be very, very interesting to see how the state does this, what they ask, where they go, what they say. Hughes also, by the way, one other thing to note. Hughes was given a 6-month jail sentence. Okay, he was given a 6-month jail sentence for the contempt of court. So let me pull that up. Let me see if I can find that news article. Zachary Hughes, contempt. So not only was John Mello arrested, but because of the continuous issues, here we go. We will, since we don't have a court feed right now, we will look at this. So you guys have the latest, most up-to-date information. All right, so here it is. Judge sentences upstate suspect to 6 months for outburst. The trial for a man accused of killing a Greer woman continued on Wednesday. Zachary Hughes, accused of stabbing Christina Parcell, took the stand. The defense is not denying Hughes killed her, but rather is trying to prove it was a just cause. On Tuesday, the defense said that Hughes would take the stand and tell the jury why he took the life. So he said basically he gets into the testimony. But the judge, this is what I guess what happened outside the range of the jury. Solicitor and prosecutor Walt Wilkins pleaded for the judge to make Hughes step down from the stand, claiming that Hughes was making a mockery of the courtroom. Hughes was instructed by the judge that he could not continue to make comments alleging that Parcell had abused her child. I put my hand on the Bible, made an oath to tell the truth, that I am a little confused. So then it gets into saying, let's see here, where does it talk about the 6 months? I guess it's at the top. DNA under the fingernails before I left. Oh, he waived his right to continue testifying and had no intent to follow the rules. Said Hughes on the judge held him in contempt and sentenced him to 6 months jail time. There it is. So Hughes remained on the stand to answer further questions. So if he were to continue to do this, okay, if he were to continue to engage in that behavior, wow, it's going to be, he could be looking at, even if he gets acquitted, he'll be looking at additional time. Oh, wow. Okay. So I'm going to warn you guys, it's going to be very, 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 it's a very short cross-examination. Nothing exciting going to happen, according to the blog. So it looks like we're going to be back in session for a minute. And then then the jury's exiting the courtroom. I guess they're going to go through the procedures of having him, of probably the defense resting, I guess. The defense because it appears they're only going to ask him one question. I won't ruin the surprise of what that question is, but they ask him one question. Jury's leaving the room, so we're going to be in session for about 1 minute. Well, it looks like about 3 minutes we'll be in session. Then the jury's going to exit the courtroom. So, hey, it's not going to be, like I said, this is a mess because of the way the judge has decided to limit the media's access to this case. And I'm very distressed by that. I think it's ridiculous. But hey, thank God the news media is there to blog what's going on so that we can at least talk about what's happening. But right now, I'll find out what's going on, preview it for you guys so you guys know. And of course, we have the Seaman Tilly trial starting at 12:30. Today is extended court hours. Remember, the judge talked about that with the jury yesterday. And of course, the feed cut off. We don't know why yesterday. It cut off mysteriously and never came back on. But that case will be on for an extended hour. Normally it ends at 7 Eastern time. It's going to go till 8 because they're going to go to 5 o'clock because the judge noted what we're all noting. He said, we're way behind schedule. And it looks like we might be here till Christmas of 2026 at the rate we're going. And that is, listen, guys, that's going to be a long trial. That might compete for OJ status because they've got, the state has a lot of witnesses. And in California, they don't know how to put on a trial that is just efficient and to the point. They allow a lot of crap that comes in. I remember my dad did a breakdown of the OJ case. He was speaking to law students. I got to watch him. And he was breaking down the testimony of Cato Kalin, which I think went on for like 4 or 5 days. And it was like, I remember my dad highlighting clips to the law students talking about how they were questioning Cato Kalin about the cufflinks that the police officer was wearing. And it was like, what the hell does that have to do with anything? Why are you asking him about that? It was crazy. But that's California for you. It hasn't changed since 1994. I don't think it's going to change anytime soon. I guess it's good for us because it's good content and keeps something for to watch when we have trials like this. We keep wanting to kick the cameras out of the courtroom. But this is where we stand, guys. So little bit of a guide for you to guide you through as you're watching today. It looks like we're probably going to get the closing arguments today. This jury is going to be deliberating today, and I would imagine the way this judge is and the way these down south juries go, they're going to try to get a verdict today. So they're not going to let these people go home. They're going to keep them, make them hang out for a while. And given the fact that the defense was extremely limited in what they were able to present, and given the fact that all they got was an utterance, couple of extreme utterances from Zach Hughes, I think this jury will come back with a conviction. As I said, I think it could be a lesser because I think maybe he got the jury's attention on this. The question will be how far the defense goes in their closing argument and what they argue and how they argue, because it's a tightrope walk for all parties involved, especially the defense and the attorney for the defense, because he's got to worry about sanctions for himself if he were to cross any lines and bring up any of the subjects he's not supposed to talk about. So we're seeing. I think the best case scenario for Zach Hughes, as I said, is a conviction on manslaughter. I think the worst case, we already know what that is. And I think if I was going with my gut, I think he'll probably get the worst case because I don't think enough is in front of this jury for them to really consider that they're going to let a man off on a lesser charge for stabbing her the amount of times he did and doing the things he did to her, regardless of what he's alleging to have known. But it'll be interesting. It'll be very interesting. But that's what's available to him. Be watching. Let's see what the defense does. And can the defense pull a rabbit out of the hat here and maybe get Zach Hughes something less? We'll watch and find out. So right now, there's been no reports as of yet as to what is happening. So not sure about that. But what I'm going to do is step away. So I appreciate everybody tuning in. And court, as I said, will be happening for us. We will be back in court at 11:37. It'll be 3 minutes long. And then we will be kicked back out again. And I'm waiting to see what happens next in the vlog, because it's kind of like having a little, I feel like I'm the guy in, what was it, Back to the Future 2 when Biff got the the sports almanac, and you can see everything. And it's kind of like the blog here is like the sports almanac. I can predict the future and tell you what's going to happen. But we'll find out here what our future holds. Like I said, I think it's going to be a lot of in and out, and then we're going to get closing arguments, and then we're going to be sitting on the emblem until things get better. Let's see. Has law and crime started? They have. Yes, they have. All right, good. All right. So with that said, guys, I'm going to step away, and I appreciate all of you, and I will be back throughout the day to talk to you as I can throughout the day, and we'll see where this case is. Oh, jury's re-entering the courtroom. All right, so mark your clocks, guys. We will be out from 11:30, from about 11:40 to about 11:40 or to 11:46. So we will have a 6-minute delay. So jury's re-entering the courtroom. We'll see what the defense is going to do. Will they call another witness? Will they rest their case? I don't know. So we'll find out. Anyways, I'll be back soon, and I appreciate everybody. Let me know your thoughts. I'm going to put a poll up on where everybody is at. So be on the lookout here in the next few moments. I want to hear from you guys. Are you convinced? Do you think he'll be convicted of everything, or do you think he'll get a lesser charge, or do you think the defense will pull a rabbit out of a hat and get a full acquittal? Do you think he deserves a full acquittal? And you as a 13th juror, having watched his trial, if you were sitting on that jury, what would you do? So let me know your thoughts. All right, guys. Talk to you.
Then it states Exhibit 66 up there on the overhead. Mr. Hughes, when you dragged Christina Parcell across the floor of the front room where you killed her, did you drag her by her arm or by her ankle?
I don't remember for certain, but I think by the ankle.
That's all the questions I need to ask this, Your Honor. Any limited redirect?
No redirect, Your Honor.
Any other witness? If that's going to call any other witnesses.
Your Honor,
And I am aware that you wanted to put additional property.
yes, not at this time.
Okay. All right. Ladies and gentlemen, I'm going to ask you to go back to your jury room, and I'm going to be taking up a few matters, hopefully very quickly, and we'll be back with you.
All right, guys. So there you heard it. That was the one question. I guess we'll find out shortly in the state's closing why they asked that question, what significance it has. It must have some sort of significance in whatever it is they believe it proves. But I just want to update you guys on where everything's at in the blow. They're going to come back in 6 minutes. The defense is going to rest. They're going to go back out of the room. It's like what? 11:41 in actuality here. I have a feeling the judge is going to probably say lunch break, and they'll do a lunch, and then they will come back and they will charge the jury, and they will then do closing arguments. I'm not sure if they charge the jury first in South Carolina or not. I can't remember from the Murdoch case and other cases I've covered there, but they're either charge the jury and go to closings, or they go to closings and then charge the jury. Right now, the judge, some of the issues that were raised earlier today. Let's see here. There's an update. Yep, this missing until 1:30. It just popped up. So the judge did grant some of the requests the defense asked to the jury instructions. They're going to remove the word victim from the harassing charges, and they're going to use the term targeted person in its place. The judge found that. Outside the presence of the jury, the defense argued motion still quit on all the charges. The judge denied those. So really, for all practicality, we're going to be out of session in this case until about 2:00, because 1:30 they will come back. There's a 30-minute delay, and then we will be then either getting a jury charge and closings, or closings and a jury charge. So we'll probably be in session for a couple of hours. And then it'll be time to see what this jury does. So let's take a look at the results so far of our little poll. We have 59% of you out there would find him guilty of first degree, while 35% would go lesser, and there is at least 6% of you out there that would say not guilty completely. So interesting numbers. In favor for as far as in when you look at a history of cases, whenever you see 41% or less than say 20 or 30% of the audience believing that the most extreme charge is what the jury will go with, it normally is a good sign for the defense. So it's a good shot here that Zach Hughes will probably walk away with some sort of a negotiated verdict back there in the jury room. Appears he's got some interest from some of you out here, and perhaps he's got a couple of people in the jury that their interest has been piqued as well as to what's going on in this case. So we will see. So, with that said, I'm going to step out here. Seaman Tilly will be starting at 12:30. I will include a link in the Seaman Tilly trial for ease to get back here and to be able to check. That way you can pop in and out. But again, put a little reminder in. If you want to hang around and see the defense officially rest, that's fine, of course. But that's all you're going to see. It's going to be really quick. Then they're going to get sent back out. And then we're not going to hear anything until 2 o'clock. So if it wasn't for this blow, we'd all just be sitting here wondering what the heck's going on. So we're going to see them come back. We're going to see the defense rest. We're going to see them leave again. We're going to see things happen outside the presence of the jury. We're going to see the judge determine outside the presence of the jury that they will reconvene again at 1:30 for the end of the trial. That's where we stand. So with that said, guys, we'll throw you back to a courtroom scene. We'll be watching, and we should see, like I said, them come back here probably in about another minute or two, and then nothing else will happen until 2 o'clock. So see you guys then.
Welcome back. Just be patient and understand there are procedures that have to go in, and I'm sorry that I have to send y'all in and out, okay? All right, anything further?
Nothing further, the defense rests.
Defense rest. Okay, ladies and gentlemen, you can go back to the jury room. attendance, we are about to begin closing arguments. Stay.
Thank you, Your Honor. Please the court. Good afternoon, ladies and gentlemen. This is the moment where myself and the defense have an opportunity to speak to you directly. It's called our closing statement, our closing arguments. All the evidence that you're going to hear in this case, you've already heard it. It's either sitting right here or it's through testimony that you've already heard. And so my goal here is to just talk a little bit about this case with you and sort of explain the state's perspective and how we have proven beyond a reasonable doubt that Zach Hughes did in fact commit the crimes that he's alleged to have committed. And I'm going to go through those crimes a little bit, and we'll talk a little bit about that. And then I'm going to go briefly through the evidence and explain my perspective on those things. I will give you a bit of a caveat that this is a little bit of a unique case in that you rarely have the defendant testifying and admitting to the entire crime during the trial. So in that respect, my closing argument may be a little different or maybe a little abnormal than our normal way we do things, but I'm going to do my best. I first want to thank you for your service. It's been a long 2 weeks. Y'all have been extremely attentive. You've paid attention. You've listened to the judge. And to be frankly, I couldn't ask for a better jury, and I appreciate your service. On behalf of my co-counsel, Mr. Jake Hoferth, Investigator Jared Sparkman, and Master Deputy Blake Wolf, we thank you for your service. Now, I told you in my opening statements that once you see and hear all the testimony in this trial, and I did not know that the defendant was going to testify, you're going to find that Zach Hughes, I don't know if you remember what I said, is a cold-blooded killer. And I submit that the state, and along with the testimony of Zach Hughes, we did in fact prove all of that beyond a reasonable doubt. Zach Hughes is a cold-blooded killer. Zach Hughes is an admitted cold-blooded killer. And keep in mind, he solved John Mello's problems. So the judge is going to instruct you on the law, and just as we're going to abide by his rulings, you must abide by his instructions. Remember I told you he's the referee, calls balls and strikes, and he also tells us what the rules are, what the law is. Y'all took an oath way long ago than you can probably remember back in last week on Monday, a week ago. And you said you would take an oath, you would adhere to his instructions, you would do your duty as jurors, and I have no doubt in my mind that you will absolutely do that. Now, before Zach Hughes admitted to the murder of Christina Parcell, the state called approximately 32 witnesses. We submitted close to 200 exhibits. If you put all this on a hard drive, it's a little over 4 terabytes of information. And all of that taken together, it's a lot of evidence to digest. Now, with the admission of Zach Hughes to a lot of the state's case, the questions you were presented with at the beginning of the case really are answered. Regardless of what he may believed in his head, his actions are what matter in this courtroom. Actions speak louder than words. And boy, do we have a lot of cold, calculated, horrific actions in this case. Now, ladies and gentlemen, you must find the facts based on the evidence in this trial and solely based on the evidence presented at this trial inside this courtroom. And it's undisputed that Zach Hughes planned, he lay and waited, he broke into Christina Parcell's home with a .22 and a knife, some roses. She had just returned home from an interview, from her last interview with Vet Tech. Zach Hughes, a person she had never met. She had never met him. Beat her with a gun, brutally stabbed her 35 times, severing her jugular vein and her carotid artery. Now, as we go through the evidence and we look at some of the different things, I'm going to ask you to keep in mind of the charges that you're actually looking at. So the first charge I'm going to explain is the harassment charge. And there's two harassment. There's harassment and there's conspiracy to commit harassment. The only difference is that conspiracy requires two or more people joining in to commit the harassment. So harassment is just a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that serves no legitimate purpose and cause that person, and would cause a reasonable person in his position, to suffer mental or emotional distress. That's related to all those photos and those documents that you saw mailed out. I think there's 7 envelopes full of photos and other documents. You heard testimony about what was in those. Some of them are in evidence. Some were just described because those were pictures of Christina Parcell without any clothes on. So we didn't introduce those so as not to embarrass her or her family. Burglary first. A person is guilty of burglary first if he enters a dwelling without consent and with the intent to commit a crime. And I remind you, the judge is going to tell you the law is, what it is. I'm just trying to give you an outline so you can keep that in mind as we're going through this evidence. And they enter without consent and are armed with a deadly weapon or cause physical injury. Well, those things all already appeared in this case. Zach Hughes went in under a ruse of roses according to his own testimony. But he went in directly with the intent to commit harm, and he had weapons on him. And then you've got murder. You also have possession of the weapon during the commission of a violent crime. That is, if you used a weapon and you murder somebody, that is the possession of the weapon during that commission of a violent crime. But you have murder, which is the killing of any person with malice aforethought. Malice aforethought. And you're going to hear those words a lot in the judge's instructions. But malice is ill will towards another person, the intentional doing of a wrong act with the intent to inflict injury. And I think I said early on, ladies and gentlemen, it was a depraved heart, an angry heart, with the intent to harm somebody. And there's also express malice, meaning it's expressed, it's right there in front of you. And it's shown when there are words of hatred or when someone prepares to do the act. They prepare to go in there. It's called premeditation, is what you'll hear the judge charge you. Premeditation is preparing to go and harm somebody, like lying in wait, like buying weapons beforehand, by concealing your identity going in there. Those kinds of things are premeditation, things that you do in preparation of the violent act. And if you find those things, and you find the state proved those beyond a reasonable doubt, then you can find the defendant guilty. So, before we get in, let's start with a little background now. You know the players, you know everybody involved in here, you know the victim. You've heard a lot about the victim, Christina Parcell. You've heard a lot about John Mello. You've heard a lot about Zach Hughes. And you've heard a lot about Christina Parcell and John Mello's daughter. So, the background, and we're talking the time frame from 2020, October 2020-ish, to October 13th, 2021. So we're roughly a time span of 1 year. And what happens throughout that year that leads up to the murder of Christina Parcell? Zach Hughes never talked to Christina Parcell. He didn't know Christina Parcell. He never met Christina Parcell. And everything he knew about Christina Parcell, even according to his own testimony, was told to him by John Mello or shown to him in certain evidence. John Mello was in a nasty custody battle with Christina Parcell. We all know that. He was on his 4th round of custody disputes with Christina Parcell. Keep in mind, and according to the guardian ad litem, the prior 3 were just as nasty, but they had always been settled where John Mello would have significant custody of their daughter. But in April of 2021, that changed. The tide changed for John Mello because he took Aida out of the country in violation of that order, according to the Italian courts. And he took her to Italy. And Christina Parcell didn't even know about that until she saw a social media post where she realizes my daughter's out of the country, I can't see or talk to her, and she's with her father. Thus, the continuation of this nasty child custody dispute. And then from October to April, Aida was living in Italy with little or no contact with Christina. So what did Christina do? She did what any mother would do, is she tried to get the return of her daughter. So she went through this process, and it was explained by Christina's sister, Tina Parcell, as well as the guardian ad litem, Vanessa Cormello. She filed under what's called the Hague Convention, and she asked to have her daughter returned to her. She actually flew to Italy twice to have these hearings in Italy. And she was successful. She won that particular battle in this myriad of battles of child custody that have been going on between these two individuals. And so in April of 2021, that really set off John Mello. He was unhappy. And we know the things, and we're going to talk about the things that he did starting that day, through the WhatsApps, through the harassment letters, everything else, to solve that custody dispute problem. And that's where this case really, really began. That is when things turned not in favor of Christina Parcell. She lost her life as a result. So, what is the relationship between Zach Hughes and John Mello? All right. So, where did they all come into this mass of characters? Well, according to Zach, he met John on the streets of Greenville about August of 2020, and he was with Aida, and Zach played a very likable classical music piece that John Mello and Aida liked. And that's how they met. So they met that one time. And that was one of the few times that Zach Hughes actually met Aida Mello. And he talked about, they went on about 4 or 5, maybe 6 occasions where they were hanging out. They got some tacos one night. They saw a museum. But Aida Mello didn't know Zach Hughes. She didn't know who he was. She's a 9-year-old little girl who heard him play a piano piece, who's a friend of her dad's. And that's all the time they ever spent together. That's it. In August until October, John Mello left for Italy. And with him went Aida. So Zach Hughes never spent any more time with Aida, what little time he did during that small time, ever, never again. Now, he may have seen her on a FaceTime while he's talking to her dad. He may have seen her or seen videos of that, which he testified to. But Zach acted on this stand as if he could see into her soul. He could see into her eyes. He knew how she was feeling. He could tell that she gained weight and why she gained weight at a certain particular time in her life, in her adolescent life. He is drawing those conclusions on a little bit of information and nothing but whatever John Mello is feeding him. So, what's their first thing? Aida's back with her mother. She, in May, begins living at Canebrake with her aunt, Tina Parcell, and that's where they're living there. John Mello's in Italy, and Zach Hughes and John Mello decide, well, you know what we're going to do? Let's embarrass Christina Parcell. Let's make her life look bad. Let's make her look like a prostitute. That'll help me get custody of her. That'll help me with the guardian ad litem. And so John Mello, according to Detective Bevel, who testified, had photos, and according to the evidence right here, he had photos of Christina Parcell. And those photos were taken when she was much younger. And those photos are taken between two consensual adults engaging in what acts that two consensual adults can do. And that's it. And then he took those photos and he used them as a weapon. And he tried to make her look like a prostitute. Because that's what John Mello continually told Zach Hughes, according to his own testimony, Alex Field's affidavit. let's make her look like a prostitute, and let's send them around to a neighborhood. Well, they sent them to a neighborhood where Brad Post lived. They didn't even send them to Canebrake. And we know this because in these WhatsApps, they talk about it specifically. They talk about, may I present to you my daughter's mother, Christina, Caroline Warren, escort. And we know there's a bunch of attachments that we can't see because Zach Hughes deleted these on October 13th. And when we retrieve them from WhatsApp, they're deleted. So you have to see us, investigator Sparkman, manipulating these WhatsApps. And then they sent them that way, and then Zach Hughes receives them. He gets them, and he sees an email that was sent to him as well. This email is very important. And he prepares all these packages to Brad Post, to Mr. Bradley Post. These are all his P.O. Box. Brad Post. Cigar bar, where Brad Post hangs out. Misspells Mr. Post one time in the WhatsApps. Misspells it here, P-O-A-S-T, which is why we know it. But Zach Hughes admitted it. But this email here purports to come from Mullen Investigations. Mullen Investigations at protonmail.com. And it's cut out. And you've got this photo of Christina Parcell, and you've got another photo of Christina Parcell back there, which is the same ones that are in here. But there's no URL with Bella Donzio right here. And this is the escort site, and it says Caroline Warren. She became a member, Caroline Warren, in 2009. Well, this is 2021. And apparently this Mullen Investigations on May 16th found these photos attached to this website. Except the photos don't have anything attached to the website. It's just a square of an escort site of Caroline Warren. Well, I don't know who that is. I know this. I know Caroline Warren. I know Mullen Investigations, John Mello. Vanessa Carmelo testified to it. She received emails from Mullen Investigations, and she received lots of emails from people purporting to be John Mello. So Zach Hughes went to the trouble of preparing all these envelopes, manipulating all the items, the photos, the escort, and putting it together, and he wanted to make sure we knew it was her, and so we would add a cover letter. You can see the cover letter that he would do. He had to add a cover letter to make sure you knew exactly who that was, that it was Christina Parcell that was engaging in prostitution. And he sent them out to shame her, to make fun of her. There's WhatsApps in there saying, we're going to ruin her day. And Zach Hughes did it the same way he committed this murder. He used his bike, he avoided cameras, tried to find a location, and he didn't know that we could track his phone. And so we know he was in Greenville when he mailed those in June and July, and he was in Tennessee when the other two were mailed. So we know he did all that. But the big point of the harassment is not that that's bad to do somebody. It's really what Tina Parcell referred to as revenge porn. South Carolina does not have a statute for revenge porn. We have harassment. And that's exactly what that is. But he's really doing it, one, to make her look bad, to make her look like a prostitute. But he's also trying to do it to gain a strategic advantage in this custody battle. And it doesn't work. He even sends one to the guardian ad litem. What does the guardian ad litem do? She investigates everything. But Brad Post put a lot of work in. Zach Hughes put a lot of work into that. It's a lot of work finding all those envelopes. To somebody he doesn't even know, he's never met, never talked to. Now, John Mello, I would say he's pretty much a liar. He dated Christina back in 05 and 06 and had their daughter in 2012, and of course this custody battle. And if you want to look about the character and who John Mello is, I refer you back to Vanessa Cormelow's testimony. She testified that John Mello would do horrific things in relation to this custody battle. To her, to a lawyer who's representing a little girl as a guardian ad litem who's practicing law for 26 years, he would accuse her of horrific things, according to her. He would accuse her of trafficking children in Spartanburg. He would post things on social media ridiculing her. And that's how John Mello operated. That's how he operated. He used deceit by using fake emails. He used threats to try to get what he wanted. Mullen investigation. He sent those to Vanessa Carmelo. He sent an email pertaining to be a lawyer named Sophia Carlucci, according to Vanessa Carmelo. And she knew it was John Mello writing it because she's read so many emails from him, they matched up. So he's trying to gain a strategic advantage. John Mello and Zach Hughes were trying to harm Christina because John Mello had a custody problem. And the only way to solve it was murder. So Zach visits John for 3 weeks in June in Italy. So he met him for 5 times between August and October of 2020. They're having lots of conversations on the WhatsApp, and he's in 3 weeks in June in Italy. And it was a pretty important moment when Zach Hughes said, John Mello offered me $5,000 to kill Christina Parcell. John Mello offered me $10,000 to kill Christina Parcell. Now, of course, Zach said he wouldn't take that money. He would just do it for free. Because killing Christina Parcell is the right thing to do. So I submit that's when the plot to murder Christina Parcell began. That's kind of when this evolved. And I think they started with the photos, which were in June and July, but that wasn't going to carry any weight with anything. Interesting that a struggling pianist turned down $10,000. Do it for free. Especially of a person he's never met on behalf of a little girl he barely knows. Now, much of what Zach Hughes said, I believe, on that stand was true. I think a lot of it was a bunch of self-serving, narcissistic junk. Zach Hughes is trying to portray himself on that stand as a hero instead of the cold-blooded killer that he is. Ladies and gentlemen, we judge the defendant by their actions, not by their excuses or their words. Actions speak much louder than any self-serving lies from a sadistic, pathological killer like Zach Hughes. He murdered Christina Parcell, mother to Aida, sister to Tina Parcell, and daughter to Erica and Tim Parcell. Now, I've talked a lot about Vanessa Cormello because she's a key witness, because that is the dispute that we're having, the custody battle. And she's in charge of making recommendations about who should get custody. Her job is to investigate the custodians. She stated that she investigated every allegation which were at Christina, which was involved in prostitution and drugs. She stated she would investigate every allegation, hire private investigators, put trackers on cars, meet with potential custodians, have home visits, and talk with the child constantly. So she's doing everything that she can possibly do. She even had allegations like Alex Fields. There's an affidavit that the defense submitted on Alex Fields, where he says that he was propositioned by Christina Parcell for sex and offered to sell him drugs. And he put in an affidavit. This was after John Mello put on Craigslist, "You have any information about Christina Parcell that I know about? I'd like to know anything about." Who responds to a Craigslist ad about somebody and then sets an example of what they did at a bar? And for what purpose? Maybe it's true. Maybe it's not true. I have no idea. That's what Alex Fields says. Really doesn't matter. While the defense wants to impugn the integrity of Christina Parcell as a justification for committing murder, so be it. If doing bad things means anyone can break into my house and stab me 35 times without retribution, then two things will happen. There'll be a lot of people stabbed to death, and I'll be out of a job, because all we'll have is vigilante justice in our system. But again, these are allegations that John Mello is making. He's looking for any dirt on Christina Parcell. Again, these are all allegations. Well, let's come to October. Vanessa Cormelo was getting close to making her decision. Who's going to get custody? Her investigation revealed that before Christina's murder, she would write a favorable report for Christina Parcell and a bad one. That's what Vanessa Cormelo said. In addition, it was almost 6 months since Aida had come home, and that's important. 6 months. Someone can file to terminate the parental rights of another. We were about to be 6 months. Zach Hughes said October was the time that he felt it was the time to kill her. Just felt it in his heart and his mind. And he tried on the 12th, did it on the 13th. That is important because it was getting close. John Mello's getting a bad report, and things aren't going to go his way, so he's got a problem. Now, if Christina Parcell is no longer around, he's the last man standing. He's going to get custody. So, Zach admittedly decides to murder Christina Parcell. That was his intent. He bought a gun and a knife about a month before. It was weighing on his soul. His custody dispute's not going well. And so he entered into a lot of planning going into this murder. A ton of planning. And the state presented all of this evidence to you before he testified. But we know that Zach Hughes on the 12th was up at the Mountain House because his phone showed that he was up there. And while up there, he had his truck. And we know he put his bike in the back of the truck. And we know he parked it somewhere. And we know that he decided to park somewhere near Canebrake and ride his bike in there. And we didn't know, but we know, that he knew the schedule of Christina Parcell that day. Because he said John Mello told him. So he gets in his truck, and I would submit he arrives around 7:42-ish to somewhere wherever he parked. We never learned exactly where he parked near Canebrake, but we know he parked somewhere there, and he rode his bike. Because at 7:42, we know from his phone that he plugs it in and unlocks it. And that's the last activity on his phone at that time. So he parks, maybe he plans, he thinks, and he gets on his bike and he drives in. And we know he drives in because he passes Donna Gorman's house. And Donna Gorman was an early witness from the state. And she did an identification of Zach Hughes from that witness stand. State was not expecting that. We had never shown her a photo lineup. We'd shown her a photo of the bike, of Zach on the bike from the ring cameras. But she had never seen Zach in person. And so we just left it. Now, we did wait until about 3 years after the murder before Donna Gorman told us that information. That is true. Riley Stokes talked to her that day, and he didn't have a copy of it. Master Deputy Wolf talked to her on the 19th, and he didn't show her a copy of the person on the bike. And so there was so much chaos going on, so many officers moving in so many directions, trying to find the evidence to solve this murder. It was just overlooked. And so when we went and talked to her, this was her testimony. And that's what we presented to this jury. She was right. She was right. The DNA proved it. Zach Hughes proved it. So Donna Gorman sees him, and she says it's around 8:15-ish when he goes by. And then he goes to Christina Parcell's house. And my opinion is that he went and he hid under the bottom of the house. His testimony was different. He says different. He says that he got there and went straight in, dropped his bike, and went to the front door. We have a difference. Maybe he's telling the truth. Maybe I'm wrong. At the end of the day, it doesn't really matter. But I submit that he went and he waited. He had an hour to wait. Of course, he had an hour drive from the Mountain House all the way to Canebrake. You know what he could have done? He could have turned around. He could have done anything he wanted. He could have gone to the QT. He could have changed his mind. Had many opportunities to do that. He was committed. And so he went and he lied and he waited. And he waited for a time because he knew her schedule and he knew her car. He knew her address. That's in evidence. And he went and he decided to walk in the front door with roses as a ruse, according to his testimony, with a gun and a knife and a backpack, paint thinner so he could clean up afterwards, and he kills her. So let's see the moments before Christina Parcell is murdered. Zach Hughes, dressed as he said he was, gray sweatshirt, backpack, black pants, walks directly into that house. I can't see if he's carrying flowers. I know he was. I know he had flowers on him. And he walks in and he surprises Christina Parcell. Points a gun at her and hits her in the head with the gun. And then he stabs, and he begins to stab, and he begins to slash, and he begins to slash, and he begins to stab, and slash. Now think of the force needed to stab someone in the chest, stab them in the back, all over the head. And finally, and through all the fighting, and the stabbing, and the pushing, while Christina is fighting for her life, he finds the vulnerable spots, stabs her in the jugular and the carotid artery, causing her to bleed out. With blunt force trauma to the head, she has to be on the ground. Blood is everywhere, pulling around her dropped phone and the couch. But that's not enough. He drags her through her own blood to cover up the crime as he closes the curtains and locks the front door so he's not detected, as droplets of blood fall from his blood-soaked clothes. She remains laying on that floor in her own blood, with nothing but her blood-soaked scrubs and her wedding band that Brad Post gave her. But his sadistic actions are not over. I submit, ladies and gentlemen, those rose petals had a dual purpose. He may have used them as a ruse to get in and get inside the house so he could surprise Christina and gain that strategic advantage to murder her. But he also sprinkled them around. He sprinkled them around the house, on her purse, around, as some sort of sadistic, artistic sign that he thought was necessary. Then he had to keep in line with the allegations: prostitution and drugs. Put a bag of cocaine under a couch, under a chair, right down from her body. Killing her wasn't enough. Shaming her was the goal, too. This was not to save Aida. This was to help John Mello win his custody case. He never told us about the drugs either. Never mentioned those. So then the cover-up. So then, after you effectuate the crime, you commit it, then you got to clean up. You got to cover up. So, he first had to cover up the scene. He had to worry about that DNA under her fingers. That DNA is key to this case. He had to wipe her fingers down with that paint thinner. He did not want to get caught. Pre-planned, and then really good exit strategy, cover up. Then he went back to the mountain house. Of course, we know he's there because his phone puts him there around 1:17. He connects to the Wynn Wi-Fi. The Wynns have a mountain house. He has access to it. Remember, it's real remote. I think Master Deputy Wool said it's so remote you could walk around naked. Nobody would see you. Perfect place to clean up a crime scene like that. Can you imagine how soaked in blood his clothes were? Can you imagine how soaked in blood his car was? Can you imagine how soaked in blood his bike was? And he did. And he admitted it. Burned his clothes, ditched the knife and the gun in some pond, cleaned up everything, and he went back to Tyndall about his daily life. And that's what he said. Now, I've mentioned Zach Hughes' testimony a lot. And I'm sorry that you had the unfortunate privilege of hearing the specific testimony of the killing of Christina Parcell by a cold-blooded, cold stone-faced killer trying to portray himself as a hero instead of the cold-blooded, calculating killer that he actually is. Only a person with a severely diminished sense of heroism, with a heart that is cold as ice, can portray that. The absurdity of many of his words and I'll reference a couple. I wanted to make her death quick and painless. is what he said. When I was listening to that, it was hard for me to comprehend that someone is actually saying that at their trial to a jury. Do we say thank you? I appreciate it. Thank you for taking my pain into consideration as you murder me? What does that even mean? Well, I ask you this. Was it quick and painless when he hit her in the head with a gun? Was it quick and painless when he stabbed her the first time? Was it quick and painless when he stabbed her the second time? How about the 5th? The 10th? Maybe the 20th? He was being considerate. Maybe the 30th? How about the final 35th blow? And then, of course, I asked him one question. How'd you drag her body across the room? And he said, I don't really recall, but I think it was by her ankles. And he looked me in the eyes in a stone-cold faced way. Told me the answer. Like he was proud of it. He said, I do not want anyone else to be involved. I waited till everyone was gone. Thanks. Appreciate that. Talking like he's doing us a favor. I wonder what would happen if a neighbor did come over. I wonder what would happen if Brad Post had showed up. I wonder what would happen if Tina Parcell had showed up. Would it be a double homicide? So we could escape and escape detection? And of course, he was so calculated, he got her schedule that day from John Mello. And then he said, I didn't want to get caught because they would connect me to John Mello. Oh, okay. So if you didn't get caught, you've solved the custody problem. But if I did get caught, then I didn't solve the custody problem because then they would connect me to John Mello and he wouldn't get custody. Then he comes in here, testifies, connects John Mello. Doesn't make any sense. Now, he talked a good bit about his background. My understanding, he's a fantastic pianist, highly trained. But he went through his resume with an ego, letting you all know how great he really was. Military service. Playing these really difficult sonatas by Beethoven. I'm going to play all 16, never been done. But he described his sister Grace in great detail as well, for some reason. He said she was a horrific person when confronted with irrefutable evidence. She would go cold, stone-faced. She would manipulate and recruit others to do a terrible deed. If you trust Grace, you're only going to get hurt again. She was a vampire and would suck the blood right out of you. Maybe he's describing himself. He said, I feel pity for her. He felt pity for Christina Parcell. How is that even possible of a human being? His heart is so mean, so depraved, that he viewed someone he'd never met and discussed the specific details of killing her, treating her like she was an elderly dog being sent to the vet to be euthanized. It doesn't get any meaner than that. Christina Parcell didn't have to die. Zach Hughes had a million opportunities to not do this. And if he did it to save Aida, there's a million ways to handle that. Vigilante justice is not allowed in this state. Vigilante justice isn't allowed anywhere. Regardless of what Zach Hughes had in his mind or what he thinks he had into his heart, he's lying to himself. Because all he had was hate and meanness, coldness. He brutally murdered Christina Parcell. So, ladies and gentlemen, it's been a long 2 weeks. I thank you for your service, and I thank you for listening to me. The evidence is absolutely overwhelming. I'm going to ask you to go back there and deliberate. I'm going to ask you to find Zach Hughes guilty of harassment, of burglary, of possession of a weapon during the commission of a violent crime, and murder. Thank you.
May I please report?
Let me get a little bit of water.
Okay. I want to start with something that Mr. Wilkins said towards the beginning of his comments to you. He said, Zach Hughes solved John Mello's problems. Yesterday, Zach Hughes told you he solved Aida Mello's problem. That's what he told you yesterday. Ladies and gentlemen, you got to watch the state. You got to watch the evidence. Zach Hughes yesterday came in here and told you under oath that he killed Christina Parcell on October the 13th, 2021. He told you that. But contrary to what Mr. Wilkins just told you, killing somebody in and of itself is not a crime. Mr. Wilkins told you that he confessed to committing the crime. That is not the case. Yesterday, Zach Hughes told you that he killed Christina Parcell, but in doing that, he did not tell you or confess to any crime. And let me be clear, and let me tell you why I say that. Every crime, and the judge is going to tell you this in the instructions, every crime has two parts in general terms. The actus reus, which is the action, and the mens rea, which is what's in your mind, the intent, that the state has to prove beyond a reasonable doubt. So it's very important that you understand this from the get-go. He did not confess to a crime yesterday. He confessed to killing Christina Parcell. But that, in and of itself, does not make him guilty of murder. That's very important. Okay? The first part of, or Mr. Wilkins had talked about how this case is unique. It is unique. And one of the unique parts about this case is that first part that I talked about, the actus reus, the action that's involved, there's very little dispute, if any. Zach admitted that he killed Christina Parcell, right? Where the dispute is, where the heart of this case is the evidence as to what was in Zach's heart, what was in Zach's mind, that the state must prove to you beyond a reasonable doubt. It must be evidence that leaves you firmly convinced. It must be evidence that would cause you not to hesitate to act. Right? That's what they have to do. So the heart of this whole case, Mr. Wilkinson can talk about the blood, he can talk about the scene, he can talk about all these things. But the heart of this case is the intent, is the mens rea. What have they proven about Zach's intent? All right? Now, let's talk more about what the judge is going to charge on the law and what they have to prove about intent, about the mental side of this. All right? Zach has been charged with murder. The state must prove beyond a reasonable doubt malice. That is the intent, the knowledge, the mental part of murder. The state must also prove burglary in the first degree, that when he entered that home, he intended to commit a crime. In this case, murder. He intended to commit the crime, which means there was a crime he committed. For harassment, the state must prove that he sent those mailers, which he admitted to doing, he sent those mailers without a legitimate purpose. And for the conspiracy, the state must prove that he formed an agreement to do something illegal. That is the mental component to this. And again, that's the heart of the case. And Mr. Wilkins, in his opening statement, said, we have to prove the state, beyond a reasonable doubt, an angry heart. That Zach was mad. That's where this case, that's where the heart of this case is. What was Zach thinking? What has the state been able to prove beyond a reasonable doubt about what was in his heart and what was in his mind? Now, you're going to hear, the judge is going to talk to you about different types of evidence you can consider. He's going to talk to you about circumstantial evidence, which is evidence that an arrangement of facts, when put together, that lead to other facts or conclusions. That's circumstantial evidence. Judge is also going to tell you about direct evidence. Direct evidence is evidence that comes from people who perceived what happened, who with their senses derive knowledge about what happened. Right? That is direct evidence. The state has the burden of proof on the mental element, and the state is going to use circumstantial evidence. That's what they're going to use. We have no burden of proof whatsoever. We entered and are going to use both direct evidence and circumstantial evidence to explain what Zach's state of mind was on October the 13th, 2021. Now, what is the state going to do to try to prove what was in here, to try to establish the burden of the mental side? Again, it's more than just the acts. That's critically important. But what's the state going to use to prove the mental component to this? They're going to use the acts, and they're going to say, they're going to use the stab wounds, the photos. They're going to use all the actions that Zach testified to yesterday. That in and of itself is not a crime. And Mr. Wilkins, he talks about stab, and I wrote this down, stab, 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 slash. Right? Gotta watch. Gotta be careful, right? This is a tragic case. Bottom line, someone died. The last thing I ever want to do is minimize the tragedy in this case. Not going to do it. All right? But when we come to talk to you about what happened, you have to have faith that what we are saying is balanced. Think about what Zach testified to and what Claire Rose testified to about Christina Parcell and what happened that day. All right? Stab, 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 slash, slash, slash. Claire Rose testified Christina Parcell was 163 pounds. Zach testified that he was 160 pounds. Claire Rose testified that there were, of the 35 wounds, the vast majority were incise wounds, superficial wounds, wounds that would have been consistent with a struggle. Zach told you that when he went inside, there was a struggle. He told you that they fell to the floor. He told you that when he got inside, his body would not do what he was telling it to do because he didn't want to do it. He did not want to have to do it. So let's talk about the circumstantial evidence that the state has offered as evidence to try to get you to understand what was in Zach's mind. The state talks about, in determining how much weight to give to their representations about their conclusions on the circumstantial evidence, just think about this. Donna Gorman testified that 3 years after this happened, having never been shown a photo lineup, with Zach's face all over the television and the internet, that she says that she saw Zach. Now, here's what is most troublesome about this whole thing. She testified that she saw Zach at 8:15. That's what she testified to. She testified she saw Zach through 2 trees in her house, that he was wearing a hoodie, no evidence other than what she said about a hoodie. In fact, Zach said that he was wearing a hat or a smaller hat. There is no way that she could have seen Zach Hughes at 8:15. Because by the state's own evidence, with the ring cameras, with Investigator Sparkman, the state's own evidence, Zach didn't even get there until after 9 o'clock. So when he says, Donna Gorman, she saw him, it's impossible that she saw him the way she said. Because she said 8:15, by their own admission, by their own evidence, Zach didn't even get there until after 9 o'clock. Think about that. In determining how much weight to give to their spin on the circumstantial evidence, think about Investigator Sparkman, right? Called him as a witness and showed him reams of WhatsApp messages. These messages were garbled, but he had a unique skill. I don't know if he went to WhatsApp school, but he spoke fluent WhatsApp, right? And he was asked to decode all of these messages for you as though you couldn't have done it yourself. But what's the most interesting thing about what he said in the WhatsApp messages, there was one message that he was not able to decode, coincidentally. The message that had the words Aida and doomed. That was the only message he could not uncode for some reason. Think about that. In trying to determine how much weight to assign to the state's conclusions or their spin on the evidence, think about Vanessa Cormello and what she testified to. Mr. Wilkins talked about how she was doing everything she could during this period to uncover it. Really interesting, and the judge is going to tell you this. You can determine or decide how much weight to give to testimony. You can give it a lot of weight, you can give it a little weight, you can give it no weight. I want you to think about how much weight to assign to the state's conclusions and that testimony, because I want to take you to one specific exchange between Jake Hofferth and Vanessa Cormello. Jake Hofferth asked Ms. Cormello, prior to October the 13th, 2021, and he said this, and they've said this throughout this entire case, prior to the murder of Christina Parcell, which is for you to decide and you to decide alone. Prior to October 13th, 2021, did you have a recommendation as to where Aida Mello should live? In other words, would you have had a recommendation as to whether or not she lived with her mother? And what was Vanessa Cormello's answer to that? And you can hear this for yourself. At the time, I would have recommended the mom. At the time. There was no follow-up to talk about other times. Can you trust that evidence? Very important. That's the circumstantial evidence. Now, let's talk about the direct evidence that you received from Zach himself as to why he did what he did. He got on that stand, he told you. Let's talk about the direct evidence. He talked about what he knew. What he knew, what he was told by John Mello. That was part of it. He talked about that. But contrary to what Mr. Wilkins said, he had a lot of other information besides just what John Mello told him. He had a deposition that Christina Parcell gave under oath in July of 2016. And you remember I asked him, after you read that deposition, what did you believe about Christina Parcell? What did you believe? He said he believed that she was engaged in prostitution. He said he believed that she had participated in a pornographic movie. He said that he believed that she had used drugs after reading that deposition. Another document that Zach got, Alex Field's affidavit. Now, this is very important to consider about this. This entire case, the state has worked very hard to distance Christina Parcell from the escort website. And they've made these conclusions just because they want to. Despite the fact that there are website addresses on those photographs, they have insisted that those photographs were private photographs, were taken by John Mello and then somehow put on the internet by John Mello, that she had nothing to do with that. Right? Think about this. And this is an evidence for you to consider. The Alex Fields affidavit, it has one page on the front, which is what he said, that they met randomly at Hall's in 2018, that she propositioned him for sex and drugs in exchange for money. He turned that down. But in the second page of the affidavit for Alex Fields, John Mello, in that advertisement, said, if you know this woman, her name is Christina Parcell, and then he puts the Caroline Warren alias in that ad. Right? Here's the question for you to consider. If he didn't think that she really and truly went by Caroline Warren online, why would he put Caroline Warren's name in an ad for people to respond to? Why would he include that if he did not think that may trigger someone who had seen her site? Why would he do that? I would submit to you, he put her name on that ad because she was Caroline Warren, and he was hopeful that someone who had seen the ad or used the ad would recognize the picture and contact him. That's the only reason why that makes sense. Let's talk about the other evidence, and let's talk about the elephant in the room. Let's just talk about it that Mr. Wilkins discussed. The planning. Right? Let's talk about that. Zach was very honest when he testified about the planning. He told you in detail what he did. In a lot of cases, planning can be good evidence. In a lot of cases. As Mr. Wilkins said, this is a very unique case. And probably one of the most unique aspects about this case is that the person who Zach believed posed the danger was the mother to her own child. Think about that. This isn't where you're home and an intruder comes in, you don't know, and it's a spur of the moment. This isn't a random interaction or difficulty. This is what Zach believed. This is a mother. The person who's charged with caring for your child. Most importantly, the person of all on the whole planet who is supposed to be the most nurturing. This is the person who is doing this to the child. The person who lives with the child, the evidence was the person who shared a room with the child, the person who's with the child all the time. So in a situation like that, where you have a belief that's grounded on documents, that's grounded on information shared with you over many, many months, when you have that belief, how do you alleviate that threat, the threat from the mom, without thinking through how to do it? How do you do that? And so I would submit to you, ladies and gentlemen, that the planning in this case, unlike most any other case, doesn't show malice because the mom was the threat. The mom was the one who posed the danger. Mr. Wilkins talked a lot about, this was just interjecting in the custody, just get John custody, get him custody, all right? If this was all about the custody, why would Zach have waited so long to do it? Right? Part of it, he was in a process. Part of it, he was working on this music project. But the other part is, Aida and John were separated for half a year. Right? If Zach wanted to fix it to solve John's problem, he would have done it much sooner. But the reason why it took so long is that Zach agonized over it. What do I do? Over time, he continued to get information. What do I do? He didn't want to do it. If he wanted to do it, he would have done it right away. And he told you that when he testified. He told you in detail about that day. He told you about it. About when he woke up, he drove to that location and he thought he was going to throw up. He told you about his hand shaking. He told you about when he got out and got on his bike, it was one pedal in front of the other, just trying to make it there. He told you about this. And you saw him testify. He's, contrary to what Mr. Wilkins said, he doesn't think he's a hero. He's never asked that. He did what he believed he had to do to save an innocent child. That's what he did. That's why it's more than just the action. He hasn't confessed to any crime. He told you what he did. And he told you the truth about what he did. If Mr. Wilkins talked about solving John's problem, right? And he intimated in his closing that an aspiring or starving, I can't remember what word he used, pianist would turn down $10,000. Interesting. As though to say he didn't turn it down. There's no evidence anywhere that John Mello ever paid him a dime to do this. None. Gotta watch the state, ladies and gentlemen. Lot of in the state's closing, lot of moral indignation. That, what do you mean try to be humane? Who can say that? What does that even mean, right? I was not in Zach's shoes. Nobody was in Zach's shoes but Zach. Nobody was. None of us has been in a circumstance where we have reason to believe an innocent child is being abused by her own mother, where her father is out of the country, the evidence is shown, with a warrant pending, can't come back. When you write an affidavit to try to put the authorities on notice as to what you believe is happening, when you call DSS and DSS does nothing, none of us have been presented with that circumstance. Mr. Wilkins said we can't condone vigilante justice. That's what he said. He said, if you find him not guilty, I'm going to be out of a job. Right? It's really interesting. The state wants you to be a legislature and make decisions for the people of the state in law and order. But they don't want you to be a jury when it comes to deciding how the law applies to the facts. Because they just want you to assume he's already confessed to it, he's guilty of a crime. They use the word murder throughout, which is a legal phrase, which is an offense that you have to find. So they want you to speak for the people of the whole state, but they don't want you to really look at the evidence. And that's what we're asking for. That's just what we're asking for. Mr. Wilkins said he could have done other things. This didn't have to happen. Okay? The judge will not instruct you that Zach Hughes had a burden to exhaust all remedies, to try everything he could to do. He tried. He tried a lot. He wrote the affidavit, went to DSS, did a lot of different things. But there's absolutely no requirement. We have no burden whatsoever. Just to continue to remind you that. We have no burden whatsoever. The burden is on the state. And there's no burden whatsoever for me as Zach Hughes' representative to try to prove to you that he exhausted every remedy. That's just not what the law says, and you don't need to prove. You don't need to even consider that. The evidence is that Zach tried. And when everything failed, that's when he acted to do what he thought was right, and that is, and was, to save Aida Mello. Ladies and gentlemen, the state talked about the mailers, and I don't envy your task. I don't at all. It's a tall task. But I do think the mailers, this piece of the case is a little bit easier for you to resolve, and let me tell you why. The judge is going to tell you that for it to be harassment, a couple things have to happen. First, the person who was the target of the harassment, in this case Christina Parcell, who's alleged in the indictment, the state must prove beyond a reasonable doubt that she actually suffered mental distress, and that a reasonable person would have done so in that circumstance. But there has to be evidence that she actually suffered distress, mental distress. There is almost zero evidence that she actually experienced mental distress in this case. Right? Let me talk more about that in specifics. There were at least 3 people who testified for the state who were with her when she gave the letters, those envelopes to law enforcement. At least 3 people. Brad Post, Dan Bevel, Mike Nicholson. Did any of those people testify that she was remotely upset? Any of those people say that she cried? Any of those people say that she was shaking? Any of those people say that she had made statements that led them to believe she was upset? Zero evidence that shows, or that even comes close to proving, that Christina Parcell was upset. And if anything, the evidence you've seen that has been introduced with nude photos of Christina Parcell online, with Alex Fields' affidavit, I think the evidence shows took a lot to get her upset or be in mental distress. So I would submit to you, ladies and gentlemen, on the harassment charge, that's something that you could go to initially and think about that evidence. And based on your recollection of the evidence, if you find that there's no evidence to prove beyond a reasonable doubt that she was in mental distress, then that's your answer on that charge right there. It's the state's burden of proof on each and every element. Ladies and gentlemen, in conclusion, the state has brought us here. And they've brought the charges that you are to consider. They've decided what to charge, and they have brought us here on these specific charges. And the charges they brought, specifically the charge of murder, is among the most serious charges there is. Doesn't get any more serious than that. Murder, the charge of murder, in contrast to what the state's position is, requires more than the act of killing another person. It requires malice. Malice is defined, and the judge is going to define this for you, as evil, as hatred. In his opening statement, Mr. Wilkins told you an angry heart, mad. Ladies and gentlemen, I would submit to you that the evidence in this case has failed to show you that you should be firmly convinced that Zach Hughes had hatred. You can be shown pictures and talked all about the acts, but when it comes to what he was thinking, what the evidence shows that was in his heart, that evidence hasn't come close. Ladies and gentlemen, in hindsight, 3 years after this happened, it's very fair for you to say this didn't happen, or this didn't have to happen, or disagree, I wouldn't have done that. Some of you may say you would have, some of you may say you wouldn't. That's fair. Bottom line. Can't say otherwise. But no matter what your take on what he did, I think it's so important that we rely on your common sense. And that was one of the things that Mr. Wilkins talked about early on, that how important your common sense is that you bring with you. And so in closing, I'm going to ask that you use your common sense that you brought with you to the courthouse and just ask yourself, does a person who kills another person with the intent to save an innocent child, does that person have evil in their heart? Does that person have an angry heart? Ladies and gentlemen, I would suggest to you that your common sense would tell you no. And that person who killed another to save an innocent child is not a murderer. I would ask that you return a not guilty verdict. Thank you very much.
Please, the court. Now the state has an opportunity to rebut, and I promise you, ladies and gentlemen, I'm going to be brief, so y'all can get to your deliberations. I do want to address a couple of issues. I want to make very clear, in this record, there is zero evidence of any kind of abuse. Not for a witness, not from any evidence. Mr. Mormon said you got to have some emotional distress from the harassment charges. Christina Parcell had a bunch of neighbors receive pictures of her without clothes on. Private photos between her and John Mello. And so what did she do? Immediately, Brad Post corralled them all up, took some from neighbors so they didn't see them, and she went to the police. Going to the police without emotional distress is not something that you see very often. Mr. Mormon talked about not trying to minimize this case. Minimize the killing of Christina Parcell. Minimizing the heinousness of this crime while trying to impugn her character. He talked about malice, and he said that you got to have an angry heart. He kept referring to me. I said, an angry heart, malice. So you're mad at somebody. And I'll leave you with this. Ladies and gentlemen, in regards to an angry heart, just because Zachary Hughes' heart is so cold and so dead that it can't be angry, that is not a defense. You prove it by his actions. Thank you.
Members of the jury, it is now my duty as the trial judge to instruct you on the law applicable to this case, and in that regard, it is your duty as jurors to accept and apply the law as I'm now stated to you. Furthermore, it is your exclusive duty to decide all the issues of fact in this case and determine the effect, the value, the weight, and the truth of the evidence. All the parties have the right to expect that you will carefully consider and evaluate the evidence and apply the law of the case to it so that in the end, all parties will receive a fair and an impartial trial. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, it is my responsibility to preside over the trial of this case, and I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If there was any testimony ordered stricken from the record during this trial, you must disregard that testimony, and furthermore, you should not even mention or discuss any testimony that I've instructed you to disregard in the deliberation room. You are to consider only the testimony which has been presented from this witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law of this case, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I now tell you the law is, you must abandon this idea because you are sworn to accept the law and apply the law exactly as I state it to you. In every case tried in this court before a jury, the jury becomes the sole and exclusive judge of the facts in a case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you are not to infer from what I have said during this process or during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during this course of this instruction to you, that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. And as jurors, it is your duty to determine the effect, the value, the weight, and the truth of the evidence presented during this trial. The defendant is charged with the following: murder, possession of a weapon during the commission of a violent crime, burglary, first degree, conspiracy, and harassment, first degree. I remind you that the fact the defendant was arrested, charged, and indicted in this case is not evidence in this case and cannot be considered by you as evidence of guilt in this case, nor does it create any presumption or inference of guilt. These documents are simply the formal instruments which contain the charges made against the defendant. It is the formal documents by which this case is brought into this court. The indictments in this case allege several different offenses against the defendant. Each indictment charges a separate and distinct offense, and you must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant has pled not guilty to these indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until and unless you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory, and it is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied for the evidence of the defendant's guilt beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you're firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there's a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find him not guilty. Facts and circumstance that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the accused. Facts in issue may be proved either by direct evidence or indirect evidence or circumstantial evidence. It is direct evidence if it proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. Direct evidence is basically evidence you can see, observe, or hear with your senses. Circumstantial evidence means the proof of a chain of facts and circumstances indicating the existence of a fact. In other words, you may infer that a particular event occurred based on proof of circumstances warranting such an inference. It is not something that one observes, but from facts one can draw a conclusion. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. The burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The following things are not evidence, and you must not consider them as evidence in deciding the facts of this case. 1, statements and arguments of the attorneys. 2, questions and objections of the attorney. And 3, testimony that I instruct you to disregard. While argument of counsel is a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting arguments, counsel often refer to evidence. However, you should base your verdict on the evidence as you remember it. Therefore, if there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely upon your own understanding of the evidence. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. It becomes your duty as jurors to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, any bias, prejudice, or other motive in this case. You may also consider the appearance and manner of a witness while on the witness stand. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions, and an exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it's not contradicted. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. It is up for you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the weight you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt, and criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. And this is how you make a determination of whether or not the elements requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either express or inferred, and these terms express and inferred do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. The defendant is charged with possession of a weapon during the commission of a violent crime, and the state must prove beyond a reasonable doubt that the defendant was in possession of a firearm or knife during the commission of a violent crime. A firearm means any machine gun, automatic rifle, revolver, pistol, or any weapon which is designed to or may be readily converted to expel a projectile. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. The defendant is also charged with first-degree burglary. The state must first prove beyond a reasonable doubt that the defendant entered a dwelling without consent. A dwelling is any building or portion of a building in which a person ordinarily sleeps. A building is a dwelling even if the residents are temporarily absent from the building. In order to prove that the defendant entered the dwelling, the state does not have to show that the defendant's entire body entered the dwelling. The smallest entry is sufficient. It may be any part of the body, such as a hand or foot, or even an instrument, such as a hook or other instrument. In addition, the state does not have to prove that force was used to gain entry. If a person enters a building by using deception, artifice, trick, or misrepresentation to get consent to enter, this is an entry without consent. Next, the state must prove beyond a reasonable doubt that the defendant intended to commit a crime, either a felony or a misdemeanor, at the time of the entry. The mere entry into a dwelling without consent is not burglary. If the intent to commit a crime is formed after the entry, it is not burglary. On the other hand, if the defendant intended to commit a crime at the time of the entry, it is a burglary even if the intent was abandoned after the entry. It does not matter that the intended crime was not completed. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. Finally, the state must prove beyond a reasonable doubt the existence of one of the following aggravating circumstances, such as 1, when entering while in the dwelling or in immediate flight, the defendant or an accomplice caused physical injury to anyone not participating in the crime, or 2, when entering while in the dwelling or in immediate flight, the defendant or an accomplice used or threatened to use a dangerous object, or 3, when entering while in the dwelling or in immediate flight, the defendant or an accomplice displayed what was or appeared to be a knife, pistol, revolver, rifle, shotgun, machine gun, or other firearm, or 4, when entering while in the dwelling or in the immediate flight, the defendant or an accomplice was armed with a deadly weapon or explosive. A deadly weapon is any article, instrument, or substance which is likely to cause death or great bodily harm. Whether an instrument has been used as a deadly weapon depends on the facts and the circumstances of each case. The following are examples of instruments which may be deadly weapons: a pistol, a shotgun, a rifle, a dirk, a dagger, a knife, a slingshot, metal knuckles, a razor, gasoline, a firebomb, Molotov cocktail, and lighter fluid. A gun may be a deadly weapon, even if it is not operating. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the person hold a meeting and expressly state in the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1, following the targeted person as the targeted person moved from location to location, 2, initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted, 3, surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person, or 4, committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including, but not limited to, a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. In determining the guilt or innocence of the defendant, you cannot consider any possible penalty for any particular crime. The punishment for the crimes is a matter for me to determine and should never be considered by you in any way whatsoever in arriving at an impartial verdict as to the guilt or innocence of the defendant. Madam Foreperson, and ladies and gentlemen of the jury, I wish to express the hope that each of you will be mindful of the importance of your responsibility. You're not called upon to serve as jurors very often, and the proper performance of the duty requires each of you to reach the height of freeing your mind of all improper influences. As the presiding officer of this court, I am vitally concerned that whatever verdict you find will be the result of your going into the jury room and confining your consideration to the evidence and the law that you have heard in this courtroom, weighing it fairly and impartially, as I have every confidence you will do. Your verdict in this case cannot be based on sympathy, compassion, prejudice, or emotion, or some other consideration not found in the evidence. Remember, your verdict must be unanimous. I will now explain the verdict form and possible verdicts. There are 2 pages to the verdict form, and this will go back with you to your jury room. Once you have received that, you'll be instructed at that point to begin deliberation. There are 2 possible verdicts for each charge, which you may find in this case, and there's no significance whatsoever in the order in which I state these possible verdicts. It is simply that one must be stated first. Ladies and gentlemen, your verdict must be a unanimous one. Madam Foreperson, when the jury agrees on the verdict, you will write the verdict on this verdict form and then sign your name as Foreperson. Then knock on the jury room door and inform the bailiff that you have reached a verdict. At that time, we will receive you back into the courtroom. Madam Foreperson, if the jury has any questions, please write the questions on a piece of paper, not the verdict form, and give to the bailiff. Everyone needs to be present when deliberating. If one of you takes a restroom break, then the rest of you should pause deliberations until said person returns. I ask that you now return to your jury room, but do not begin deliberations until you are told by the clerk or the bailiff to do so. There are matters that I must discuss with the attorneys before you begin your deliberations, and if my 4 alternates will remain in the courtroom. Madam Foreperson, I've received a question from you. The question, well, it is define malice, and then the question is malice required for murder charge? And the answer is yes. Please listen as I recharge you on murder. The defendant is charged with murder, and the state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either express or inferred. These terms express and inferred do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation going to show that the deed was within the defendant's mind would be express malice. Thank you. You can return to your jury room. You can put that back in there. Okay, ladies and gentlemen, I received your question asking about first and second degree harassment. Harassment first degree. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1. Following the targeted person as the targeted person moved from location to location. 2. Initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted. 3. Surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person. Or 4. Committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Harassment second degree. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including but not limited to a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. Okay? You may return to your jury room. Madam Foreperson, I've received your question concerning conspiracy and as it pertains to first and second harassment. Conspiracy. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the persons hold a meeting and expressly state the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. That's the charge on conspiracy, and I would ask you to go back and then look at the verdict form for your direction. Thank you. You can go back, and if you have another question, I'm sorry, I just need to abide by procedure, okay? All right.
All right, everybody. So I thought I'd tune in here and give you guys my thoughts on what's happening here, because I think that I think the jury is. I wasn't aware of the first question until just now. I went in there and was going back because I've been on the road, out running errands and doing various different things. But I think I'm concerned. I'm not concerned, but I think based on the question of malice that was asked earlier, and then we'll get to the other things. I think they've already made a decision on things. I think we're going to get a manslaughter verdict. That's what I think. I think that's what that told me, because I think there are jurors back there that are struggling with the idea that he had malice, and there was a question back there. They're debating it. I think they settled it, and I think now they are moving on to try to settle the harassment. So I think we're going to get a verdict probably within the next, what time is it? 5:57. So I think we're probably going to get a verdict very soon. But I think they're I think that they're compromising. I don't think they're going to go not guilty. I would be very surprised on that. But I think they're going to go with manslaughter. I do believe they were charged that they could go with manslaughter in this case, and I think that's what they're going to do. And then I think they were struggling, because if they were going to go with the M word that I can't say on here, I don't think there would be a struggle on the lower charges, because I think that if he's found guilty of the top charge, it all just comes in, because the intent obviously would have been indisputable at that point. Best believe that judge is going to give him 20 years. So he'll face 20 years in prison. But that's what I think is going on right now. Could be wrong. They could shock me. But I think that that's based on that question. I think that's where the jury's at. But we'll see. We'll see. But I wanted to jump in here and weigh in on that, because to me, I'm very surprised at this point that we are taking as long as they have. Hold on. You know what? I might not even be coming through right now. I don't. Oh, no, I'm frozen. I see. Okay. I just was testing. I guess you guys can hear me, but I'm frozen. I don't know why that is. Hold on here. Let's all right. So now I'm moving. So I think what happened here was, unfortunately, I'll use my phone camera works a lot better. So I use my phone camera a lot of times if I'm at home, and I'll get it set up, and then I'll switch off to a different camera that is not as that I don't like as much. And I ended up having to switch between the two, so it froze me. So I apologize. But I believe you guys can still hear me. But what I was saying, if for some reason the audio wasn't coming through, although I think it is or was, it's my belief that I think they're going to find him guilty of manslaughter. That's what I think this is going towards. And my belief is, and I'm going to double check it, manslaughter is, let me double check this. I believe the sentence for manslaughter let's see here. I'm waiting for the answer here to confirm. I want to make sure I've got this right. So the definition, it is 2 years. Oh, sorry. It's 2 years to 30 years. I apologize. Involuntary in South Carolina. I don't know where I got 20 at, but it's actually a minimum of 2, a maximum of 30. So I assume the judge would give him the max. And an involuntary, if they were to go all the way down to involuntary, which is an unintentional killing, I don't believe they'll do that. It would be unlawful killing in the heat of passion upon sufficient legal provocation. So I think I think maybe where they're going with this is voluntary manslaughter, which means he would do he would be getting anywhere from 2 to 30 years. Basically, that would be something that the jury would find would be in a heat of passion. Now, I don't think South Carolina has good time. Let me see if they do. How does good behavior work in South Carolina? How does good behavior? All right, so let's. I'm going to share this with you guys. All right, so I don't know if you guys are seeing the screen share or not. Hold on, I don't think it came through. Oh, I never turned it on. That's why. Jeez. All right, hold on a second. I got to turn it on first. All right, here we go. All right, so here we go. So I'm looking this up in ChatGPT. So, it could be wrong, but I don't think it is. So in South Carolina, inmates may earn sentence reductions for good behavior, but the sentence depends on the nature of their offense. Eligibility, convicted of offenses other than no parole offenses, can receive good conduct credits. So the credit rate is earn a deduction of 20 days for each month served, provided they adhere to institutional rules and maintain good behavior. No parole offenses. These are specifically defined under South Carolina that typically do not allow for parole. Inmates convicted of a no parole offense can earn good time credits. These inmates earn a deduction of 3 days for each month served, contingent upon good behavior. Minimum incarceration requirements, regardless of earned credits, they must serve at least 85% of their sentence before becoming eligible for early release if it's a no parole offense. So let's ask them, is manslaughter, I don't believe it is, a no parole offense in South Carolina? So let's just see here. It's considered the most serious offense, carries a prison sentence range of 2 to 30. Despite being a most serious offense, they are eligible for parole. Okay, so they are. So typically parole consideration occurs after 1/3 of his sentence. So he would be parole eligible after 10 years. And 1/4 of their sentence for involuntary. So 5 years would mean it'd be about a year. He'd already be, based on the time he served, he would already be on his way to getting out. Based on the time he served, he would be only maybe 6 years away from getting parole eligible for voluntary if he got 30 years. Now, if he got 2 years, he could walk out. So, I mean, he could technically get time served under both voluntary and involuntary. Let's see here. Let's see if ChatGPT can do some math with good behavior credits. Credits. How long in South Carolina? How long would someone serve of a 30-year sentence? All right, so let's just see if they can do the math here. We'll see how good AI is here. So South Carolina, reduced, but eligibility depends on no parole. So scenario 1. So 30 years, 20 days per month, that would equal 20 years. So with good behavior, he's going to technically serve 10 to 20 years if he gets manslaughter. So 10 years, it would be closer to 20. So if he gets the max, which probably he will, then he would get 10 to 20 years, basically, is what he would be looking at if he were to be found guilty of manslaughter. And then any of the other offenses he's got, the harassment and all of that, which the jury's debating, I would imagine the judge would, because those are separated offenses, they're not part of, so those are all separate incidences. So there would be a basis to go consecutive on those sentences. So he'd be facing some time on those as well. Let's see here. What is the charge? It's harassment, I believe. What are those? First degree harassment. Explain the difference between first degree conspiracy to commit harassment. First degree. Okay, so let's ask, what is the penalty in South Carolina for first or second degree harassment? And first or second degree conspiracy to commit harassment. All right, so let me get this up here for you guys to see. Turn this on. There it is. All right, so in South Carolina, harassment offenses are characterized in degrees, each carrying specific penalties. While the law addresses harassment in both the first and second degree, it does not explicitly define conspiracy to commit harassment. However, general conspiracy laws may apply. So the definition is engaging in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that serves no legitimate purpose and causes the person to suffer mental or emotional distress. So it's misdemeanor offenses. That's second degree. So that second degree is 30 days. Enhanced penalty if the offender has a prior conviction of harassment or stalking within the preceding 10 years, or if an injunction or restraining order was in effect prohibiting the harassment, the penalty increases to a fine of $1,000 or up to a year. And then in the first degree, so it's probably quite substantial difference. This is similar to second degree, but involves additional aggravating factors such as making credible threats or targeting a person under the age of 18. Standard offense considered a misdemeanor, with including a fine of up to $1,000 and up to 3 years imprisonment, or both. Enhanced, if committed while an injunction or restraining order is in effect, it could increase up to $2,000. If the offender has a prior conviction for harassment or stalking within the past 10 years, it escalates to a felony punishable by a fine of up to $5,000 or imprisonment of up to 5 years or both. I wonder if they would. I don't think they would be able to do that because he doesn't have any prior convictions. So I don't think they would be able to enhance it. So I think he would be subject to up to 3 years on each offense. I would say the judge would be inclined to go that route. There is apparently not a law that does not specifically define conspiracy, but the general conspiracy statute applies when two or more persons agree to commit an unlawful act. Conviction of criminal conspiracy is a felony, so that's going to be a felony. Imprisonment for up to 5 years or both. Importantly, the sentence for conspiracy cannot exceed the penalty for an unlawful act that was the object of the conspiracy. So he would face up to 3 years for that, because 3 years is the maximum unless they found an enhancement. But I don't think they'd be able to find an enhancement in this case. Oh, verdict is in. Okay, hold on. Let's get back into court. Let's get back in and stop analyzing. So give me a moment here and we will get back to court. All right, so it looks like I don't know if we're going to be subject to the delay. I've got my eye on it. I'm out of the research materials because I don't want to be researching stuff and figuring it out. But and then all of a sudden we miss a verdict. But we're in. Hold on. All right, we're going in.
I say this in every trial, that there are a lot of emotions. And I would just ask right now, if you cannot control your emotions, I'm going to give you an opportunity to leave. Otherwise, you're more than welcome to stay. But for everybody involved, please control your emotions, okay? If anybody needs to leave, they can. All right, bring the jury. Madam Foreperson, I understand that you have a verdict.
On behalf.
If you can, please stand to the bailiff. Madam Clerk, please post.
Your Honor, these are case numbers 2024 GS 23 2194, 5425A, 5413, 5412. As to the charge of murder, we, the jury, find the defendant guilty. As to the charge of possession of a weapon during the commission of a violent crime, we, the jury, find the defendant guilty. As to the charge of burglary first degree, we, the jury, find the defendant guilty. As to the charge of harassment first degree, we, the jury, find the defendant not guilty. As to the charge of harassment second degree, we, the jury, find the defendant guilty. As to the charge of conspiracy to commit harassment first degree, we, the jury, find the defendant not guilty. As to the charge of conspiracy to commit harassment second degree, we, the jury, find the defendant guilty. Signed by our foreperson. Ladies and gentlemen, if this is a verdict you reached in your deliberation room and this is still your verdict now, please raise your right hand. Thank you.
Anything from the state? No?
Nothing from the state. Nothing as relates to the jury, Your Honor.
Okay. Ladies and gentlemen, I've told you this before, and on behalf of the state of South Carolina and Greenville County, I want to thank you for all of your service for the last 2 weeks. I know this has demanded a lot from you. You all have been extremely attentive. I know that this has not been easy. I'm going to ask you now if you will go back to the jury room, and I will be back there in just a moment to talk to you, okay?
Yes, sir.
Okay. You think you can do
Your Honor, at this time, I would just make a request that sentencing be deferred to give defense counsel more of an opportunity to present mitigation.
State?
Your Honor, we would oppose that request and would ask that you we proceed with sentencing as soon as possible.
I'm going to give 15 minutes. Fill out them kind of sentencing sheets. Do you feel like you need a little bit more? But I'm going to sentence them within the next 30 minutes.
Thank you, Your Honor. The other thing I would, on behalf of the jury, for reasons articulated, specifically that that the state did not produce sufficient evidence on each and every one of the elements of the offenses for which the jury convicted or on which the jury convicted Mr. Hughes, you for that reason would permit it for a new trial.
Okay. And your motion is denied. You're protected on the record. The only other thing that I need to do is just, and I had discussed this with counsel, as far as the verdict form up at the top, it just needs to be amended to read 2022 GS 23002194, and then it will be 2024 5425A, 2024 5413, and 2024 5412. I just wanted to make sure that that was on the record. It was just more of a typographical, the 4 instead of the 2.
Yes, sir.
Okay.
Yes, sir. You have no objection.
No objection. Yeah.
What? And I'll just write on here. Thank you. All right, we'll be back in 30 minutes, 15 minutes.
15 minutes be fine.
Okay, all right.
All right, guys. So you see it right behind me. That's the scene. I believe those are supporters of Zach Hughes, to my knowledge. I believe behind where that they're showing. That's at least the defense side of the courtroom. So you heard it. Convicted of everything. I was wrong. I thought they might have been negotiating a lower verdict. But I thought they would come back quicker than they did with a full guilty verdict, because, again, I just don't believe there was enough fleshed out in that courtroom that would have allowed for them to come back with anything different. Now, some of these jurors will find out how they feel when they find out. I'm sure they will look up things on the case. I'm sure they will see that there's things that happened that, they were not privy to. And we'll see how they feel about that. I don't know that it would change their verdict, probably, but maybe. You never know. It might have gotten them, especially if there was any debate going on whatsoever as far as whether he should have been convicted of the top offense or maybe a lower offense. It could very well make a difference in their opinion. So, tough situation there, of course, for everyone involved, especially for the supporters there who maybe know a little bit more than we do in terms of the facts and exactly what everything showed and whatever, again, all the different circumstances and things that were known that we're not privy to, because there is a lot, supposedly. I don't know. But it appears the judge is going to sentence him. You heard the defense was asking for mitigation. I find it interesting the level that this judge is willing to go to just keep all of this stuff out of the public sphere. It really bothers me, because one of the reasons why he's in the state too, mitigation, in fact, all of this information should absolutely be allowed in at this point. In other words, there should be able to be a presentation done to show that at this point there were mitigating factors and circumstances. Now, do I think that it's going to make a difference with this judge? Absolutely not. So let's see here. What is the sentencing options here? I'm going to look it up. Sentencing options. But I think this judge is going to throw the book at him in every way, shape, or form. All right, so let's take a look here. Give me a moment here. We're going to jump in and take a look at this. All right, so here it is. This is the options the judge is going to be left with here in a few moments because of what he was convicted of, which is the unlawful killing of another person with malice aforethought. And the death penalty is an option. It's not an option in this case. So the judge has two options: life imprisonment without parole, which is what this judge is going to do, or a minimum of 30 years imprisonment. And basically he's got to do at least 30 years in prison. So I don't believe the judge will go with anything less than life without parole. But I will find it very interesting to see that should this judge decide, hey, I'm going to go with life without parole, and he didn't even give the defense a chance to have a mitigation hearing and to show why maybe something less than life was appropriate here. We'll see if South Carolina appellate courts have a problem with that, but they may not. I don't know. So let's see here. I assume this is no parole offense is, you know, in other words, you'll get 3 days good time. So let's take a look at this here, guys. Okay, thank you, XKill Twitter. I appreciate that. Letting us know that. I assume, are they on the Fitz News website? Is that where they're at, or can you actually access documents, XKill Twitter, on the South Carolina court sites? All right, so let's jump in here really quick. And here is what our good friend ChatGPT has to say. In South Carolina, a conviction for the Big M carries severe penalties, including the possibility of a 30-year sentence. Under state law, the Big M is classified as a no parole offense, meaning individuals convicted of the Big M are ineligible for parole. Therefore, if sentenced to 30 years, individual is required to serve the entire 30-year term without the possibility of early release on parole. So there's no parole available. Mandates that the individual serve the full duration without the possibility of parole. So he's going to either be given, it sounds like 30 years. What about good behavior? Let's apply good behavior to that. Good behavior effect of a 30-year sentence. All right. So here we go. Let's see how that goes. Let's see what it comes up with. In South Carolina, it is a no parole offense. So according to state law, they're ineligible or any early release for they can't earn anything. So he's got to serve. So he's looking at 30 years, which I believe by now he's served about 4 years, going on 4 years. So he's got another 26 to serve. Life with no parole. That's it. Those are the two options. So we know what this judge is going to do, though. Absolutely do. So with that, that is, I'm sure, disappointing for his family. And let's see here. Yes, on Fitz News. That's what I thought. Yeah, I'm going to have to go in there and read those now that the trial's over. And look at them. Because I know the daughter. I know suits were filed. I know there was a lawsuit filed against the estate. I mean, like I said, that young lady was mistreated, and it's been confirmed that a lot of what he said on the witness stand was true, or some of his concerns were true. So, at least I can't say they were true. I wasn't there to see it, but they were being confirmed by the daughter. So, that's where we stand on this. So, I don't know. I think this sentencing is going to be a mere formality, because this judge has gone above and beyond to ensure that the outcome we just saw was the only outcome that would happen. And I can't imagine that he doesn't follow through and complete, the process here by leveling him with a life sentence. And I'm not saying, hey, listen, I understand he thought he had good reason to do what he did, but it's still very concerning that somebody would do the violent act he did to the degree that he did, and then say, okay, yeah, we're just going to let this guy walk among us. I don't know. You have to think there had to have been a different way to go about this, but we can't say that either, because this is the issue I have, is we were not able to flesh that out in court. We were not able to look at all of these factors because he was denied the ability to put on those defenses. He was denied the ability to put on evidence that would have been required if he was putting on those defenses. And as we discussed earlier today, some of the information that's present suggests that some of those defenses might have been able to have had some merit or teeth, because as this thing was developing, there might have been a way for the jury to have seen this, at least maybe not even seen this as the big M, but maybe as a lower level offense. But I don't know. I think that when you go stab someone 31 times, I find it hard to believe you're gonna convince a jury to let you go back into society. And really, you should. I mean, that's, like I said, it's disturbing on a lot of levels. It's disturbing what allegedly was happening to the young lady. It's also equally disturbing that, again, yes, I do know that. Yes, Jamie, that's what I've been saying this whole time. Is that post, the guy who testified in court, who was the state's witness, this guy is, this guy's under arrest. He's in prison right now, or I don't know if he's in prison. I don't know if he's been convicted or not, but he's under arrest for offenses related to exactly what. So, I imagine the same solicitor office that's prosecuting this guy, is also prosecuting Post. So they're aware. They know what's on these hard drives. And again, it's disturbing that they would deny some of this stuff to come out. Oh, they're all in the same jail. Wow. Well, I got a feeling they're being kept separate. Because I can assure you there's a guy right now that if he gets sentenced to life with no parole, there's a certain somebody who got convicted today who's got nothing to lose. And if he could get his hands on Post, I'm sure he would. It's disturbing, the Pat G. It is disturbing. It's beyond disturbing, and it's a subversion of the justice process. And I don't agree with anybody who stabs someone 31 times to settle something. But the question is, and if this was done, if there was no other option, if law enforcement was failing to protect the child, if there was nothing else that could have been done, and he did this, then that should be considered in how it's dealt with. That does not mean he should walk away free. But should he be there for the rest of his life? That's something that is, again, and should it be classified as the big M? But the fact that the judge and the prosecutors got in the way of that is beyond disturbing to me. And the fact that so many people are okay with it seems, and are willing to say, well, hey, the end result. Well, let me tell you something. If we were sitting here watching a trial for the mom, the victim, and if it was proven in court that she did what he said on the witness stand he did, I can only imagine what a chat would be filled like on Law and Crime with all of the things people would have wanted done to that person. And this guy went and did that. Now, and if it was happening, I don't think you let the person walk, but I think you also have to craft a punishment that fits the circumstances. He went, and in the circumstances being, he went way above and beyond 31 stab wounds. So, there's got to be something there done. But, it's a disservice to the story to not have let this whole story get told. Oh, you did? Oh, wow. So I guess you must not, did you know him, or were you unaware you were even working beside him and he was just a quiet guy that didn't bother anybody? Well, that's what I mean. But even if he was grooming him or whatever Mello was doing, but if this guy acted out of that belief, then he could not have had the state of mind that allows him to be convicted of what he got convicted of. And it's only because this jury was not allowed to flesh this out, was not allowed to hear this, was not allowed to be aware of all the facts and circumstances of what was known and wasn't known, that this was going. Oh, the Pat G. You were buddies. Okay. Okay. All right. Well, Pat G., you knew him. So what's your opinion of him? I mean, do you agree with the assessment here? I mean, well, I mean, that's the whole idea here is that someone who's caring about others to do what he did, if he did it for the reasons he said he did, it's the ultimate act of caring about someone. And it obviously, gets messy when you do it the way he did it. And when you start counting the outcome of it and counting the stab wounds, I mean, sometimes it's just the process of doing something like that. But like I said, that's why I'm saying it doesn't mean he shouldn't get something. But if he did it for the reasons he said he did it, then I find it really hard to stomach that that they're going to treat him like they would somebody who did some intentional heinous act. And that's what the state argued today. And that's why I have a problem with that. And I believe that, this should have been fleshed out. We should have had an opportunity as the public, and the jury should have had an opportunity to be informed jurors. And the really bothersome part about this is the jury came to a verdict, but they were not informed. At the fiance, right? Yeah, definitely. I mean, he sounds like he's a really nasty person. Jamie, I was thinking the same thing. I kind of had that about him, that there could be possible there, but well, the thing is, I mean, I think that's the hard part here is like, his attorneys are arguing that he doesn't meet the definition. The elements of the Big M were not met in this case because basically, if he did this for the reasons he did, he couldn't have had malice in his heart, so he couldn't have been guilty of that. And that's just that, depending on why he did it, And the thing is, he seems like a religious individual as well. He said he prayed on it. I mean, I think that there's just got to be a different way to deal with this situation. Maybe. I mean, listen. I mean, the fact that he was able to do what he did musically, that some that could be an indication that. But the thing is, I think what it comes down to though is the influence, and the fact the concerning part would be allowing someone like him out if he was influenced. If it turned out these things were not true, or maybe not as severe as what he thought they were. And the fact that he was able to be convinced and then moved into action in the way he was, that's a concern, right? So there's a protection of the public aspect that's got to be there because you can't have somebody running around who just decides I'm going to go, do what he did to this lady. And if there wasn't, I don't know what was done. I got to go, I guess, take a look at this lawsuit and see the facts for myself now that the trial's over and fully flesh this out. But I'm just disappointed. I'm really disappointed in the criminal justice system in South Carolina for not entrusting the jury with all the information and not having the confidence. And the thing that bothers me is when you try to keep something out, that tells you that the judge and the prosecutors both would have felt that if this would have all come in, it would have changed the outcome. And if that's the case, then they shouldn't have allowed this outcome to happen. Because if it would have changed the outcome, it means they know some of this is true, but it means that for some reason they're afraid to let this guy out or to let this guy get something less. And they're afraid of whatever blowback they see happening when the public finds out whatever it is that went down and how it all went down. And they're willing to sacrifice this guy because of what he did and the 31 stab wounds. But it's just very weird, very concerning. And I don't think this is a case that's going away. Obviously, it's not because Mello is going to be tried. But I don't think it's going to go away for him because I think there will be more when this heads to the appellate court. And the same appellate court, albeit that is considering reversing the Murdaugh trial. Remember, so if they have the courage to reverse something like the Murdaugh case, Well, believe you me, they're gonna err on the side of the Constitution and on the law, it appears, and they very well could reverse this case as well if they disagree with the way this judge conducted himself and with the way the judge limited it to testimony, with the way they treated this guy. I mean, look, he should have been able to tell a story at a very minimum, and some of this should have come in. But it's all going to be up for review, and we might be sitting back here 3-4 years from now watching round 2 of this trial play out, but with more information coming to the jury. And maybe by then they'll work out a plea deal or something. I don't know. Prevent this. But that's the other interesting thing is they sat out and let John Mello sit out for years and then only arrested him when this guy testifies. I mean, I guess they have him on the record so they can read that testimony to a jury. But the state's arguing that, well, I guess the state's arguing that, I don't know. It's weird because it's like the basis of what they're saying is they don't believe that. I guess their argument is that he got this guy upset so he could win the child custody dispute. Absolutely. Listen, the amount, and it's not just his family. I do believe, I do recall there is other supporters online and elsewhere that are supporting him and supporting giving this case an airing as far as the true facts, the hard to see facts of this case. It looks like they're back. So I think there's more ground support for this guy than just those people in the courtroom. It's just
counsel approach briefly. Okay, I'll hear from the state.
Thank you, Your Honor. Please, court. We're prepared for sentencing. what we're here for today. You've heard a long 2-week trial. You've heard the actions of the defendant. You've seen the extreme violence in this particular case. Calculated the premeditation. The jury's found him guilty. Your Honor, the state would be requesting a life sentence for the murder and for the burglary first charges. But before you switch over to the defense, I have Christina Parcell here who would like to address the court, which is the sister of Christina Parcell.
Thank you, Ms. Parcell.
Thank you, Your Honor. I will apologize in advance. I didn't expect to actually reach this point today. This is my second victim statement in 24 hours. Yesterday was reliving the 2 worst days of my life, between hearing the step-by-step account of my sister's murder, Mr. Mello's 2 new charges, his bond hearing, and my niece being put into emergency protective care again. So I am exhausted, and I'm going to do my best to express myself appropriately. So with Your Honor's leniency, just give me a bit of grace. My understanding is this conversation is with you. This isn't with the defendant. This is not with counsel. This is not with the gallery. So this is a conversation with you. And I've had 3 years to try to articulate how this has impacted me, and I still have yet to find the words, and it won't happen tonight either. So I've decided instead to talk about what logically should be taken into consideration for any sentencing, which is remorse, rehabilitation, and recidivism. This defendant sat on that stand with full disregard for the authority of the law when it came to his actions outside of this courtroom, and blatant disregard for the authority of law inside this courtroom. He recounted step by step in excruciating detail everything he did. And if I may paraphrase the defense counsel's closing statement, did he cry? Did he shake? Did he look visibly distressed? He said the word repulsed, but did he once look repulsed? He said the word vomited. Did he ever once look nauseated as he described dragging my sister through my living room? Cold doesn't begin to describe the lack of emotion. And if I may be blunt, if we're going to argue somebody has to have malice and hate in their heart to be capable of murder, then one could also argue that anyone medically diagnosed as antisocial personality disorder is therefore not capable of committing murder. I think that is a logical fallacy, is asinine, and the fact that I'm tired, I will no longer go down that, but there has been no remorse once shown by this defendant in this courtroom. Without remorse, you cannot have rehabilitation. Rehabilitation requires acknowledgement that I have done a wrong, I have a debt to pay, and I can improve to become a better member of society. It begins with remorse. Without remorse, there is no rehabilitation. Without remorse, without rehabilitation, you have recidivism. This man, no, I'm sorry, this defendant wanted to kill someone. He joined the Marines, specifically the infantry. He wanted to kill someone. He was given a target on a silver platter. He was given an address, a date, a time, and he planned it. Because he knew that if he planned it just enough, he would never get caught. He planned it so much that he thought, well, even when I got caught, I got this. I can still get out of this. Without remorse, without rehabilitation, any person that goes through that effort to commit a murder would absolutely do it again to see if they could. You're left with either two options. Either he is a weak, easily manipulated man who would kill anybody that anyone asked him to, or he's not. A weak and easily manipulated man. And if that's the case, then he absolutely would do this again to see if he's smart enough this time, to see if he can beat it this time, because he has shown no respect for the law of this courtroom. The only thing that I will say about this situation overall is that all of these men did nothing but use my sister. John Mello used her to create a whole new family when he had a wife and children already. Brad Post used her. This defendant used her. All of them used her for their own twisted personal gratification. He would do it again. Without remorse, without rehabilitation, you will have recidivism. Thank you, Your Honor.
Thank you, ma'am. Anybody else from the state? Okay. Defense.
Your Honor, may it please the court, Your Honor's presided over this trial. Your Honor is aware of the evidence that was presented at the trial. Your Honor is also aware of the evidence that was proffered. We do believe that could go to mitigation, so we would ask Your Honor to consider that very carefully. Zach has no prior criminal history, and he stands ready for sentencing. Your Honor, I would ask for Mr. David Hughes, Zach's father, to have the opportunity to address the court briefly.
Yes, sir.
Just stand right there.
Thank you, Your Honor, for the opportunity to speak a few words on my son's behalf. The trial is over. A verdict's been rendered, and we accept that. But what I want to speak to, because I understand this is the sentencing phase of the trial, where you have some parameter of your sentence. My son is probably, in my lifetime, and I've run into some pretty amazing people, and this is going to be seen as a bias from the father, but he has got such a strong moral compass and fortitude and desire for the truth in his life than really anyone I've ever met. He actually eclipses a lot of those things that I aspire to myself. It's what makes his music so incredibly meaningful, because as a musician, and there are some world-class musicians sitting here today, colleagues of Zach's, what makes a musician's art come through is what's the essence of who they are. It's not something you can fake. When you hear it, you know it's a fake. When you hear music that causes people in a room to weep, you know it's coming from something inside that person that you cannot describe. Zach was not born with a silver spoon in his mouth. I want to tell you that. I taught all my children, Zach being the oldest, the value of hard work. He might have been the only person at Juilliard to show up without manicured fingernails and calluses instead. He worked hard. I pushed him hard. Fathers and parents tend to do that with their firstborn child. And maybe I pushed him, a little hard at times. But it made him the man he is today. I want to address something, and Mr. Wilkins?
I got to just address the court date. I'm sorry.
That Zach is a cold-blooded killer. I am sorry. Zach wrote his mother and I a letter delivered to us through his attorneys approximately a month ago. In that letter, he described basically what he did in that chair over there, only in a little more detail. Why he did what he had to do, what he felt he had to do. You heard him say in that chair, he wasn't going to go on a cruise ship to Bora Bora, where he was headed, and look at himself in the mirror at night after playing beautiful classical music for rich people. He couldn't do that. Zach has been brutally honest in his life. So much, sometimes to the detriment of his own career. Everybody in the piano world wants to be a soloist with an orchestra. But it's a very small amount of room on the head of that pin, and that's where he was headed. But he had people in his life, donors, rich benefactors, who made demands of him artistically in exchange for their financial benefit, and he walked away from it to the detriment of his own career. Why do I bring that up? He has such a strong moral compass and a desire for the truth that sometimes he actually hurts himself. His friends here, all these people in this courtroom for the last 2 weeks have been here day in, day out, some as far as from Seattle, Washington. They're here because they grew up with Zach in the music world, and they saw something in him they didn't see in anybody else. He has got a loyal circle of friends that I never had. I told my kids when they grew up, if you, at the end of your life, you end up with 2 or 3 people in your hand that are really there for you, that's the guy I want in the foxhole with me, consider yourself lucky. Zach's got a dozen of those. Why? Lutina, I'm sorry for your loss. I'm not supposed to mention her name. I'm sorry. But I want you to know, Zach had felt compelled to do what he did because of what he would quote Edmund Burke on this. The only thing necessary for evil to prosper is for good men to do nothing. Okay. His desire for the truth and his truthful telling of what happened. I mean, he sat there and he didn't hold anything back that would benefit his portrayal to this court. He's just as brutally honest with himself as he is with other people. He has no criminal record whatsoever before this event. The only thing I know of is an outstanding traffic ticket in Italy somehow he rang up when he was there with Mello. And several of the guards in the detention center, where he's been for 3 years, he's been an exemplary inmate, have told him that they were going to come to this trial to support him. When you gain the silent respect of law enforcement officers, they see something in you, they see it all. And they see a guy that's respectful, for 3 years without a single incident, I think that counts for something. So I'm just here, I'll wrap it up. As you determine your sentencing, I would ask you to consider what type of man he is, and take that into consideration. I love my son. I'm proud of my son. Thank you, Your Honor.
Anything else from the state?
No, Your Honor.
Your Honor, just for the purpose of the record, I don't, would Your Honor want to inquire Zach as to whether or not he wishes to speak?
That is up to you. I'm sorry, I thought that you had indicated that.
He does not wish to speak. I just want to put that on the record.
Okay. Zachary David Hughes, Indictment 2022 GS 2302194, indictment for murder. You're to be committed to the State Department of Corrections for life. Indictment 2022 GS 2302194. You're to be committed to the South Carolina Department of Corrections for 5 years. That is to run concurrent. Indictment 2024 GS 2305425A for burglary first degree to run concurrent is for you to be committed to the South Carolina Department of Corrections for life. The other two indictments, 2024 GS 2305413 for conspiracy to commit harassment second degree is 30 days time served. Indictment 2024 GS 2305412, harassment second degree, 30 days time served. You're to be dismissed.
Thank you, Your Honor.
All right, guys. So I figured I'd say a few words here before we wrap it up here. And not a surprise, the sentence. Not a surprise at all. So, I think it was par for the course. I will say this: the father, incredibly well spoken, did a good job. I can tell he believes in his son. I can tell that obviously he's seen things we haven't. On the other hand, the sister is incredibly supportive of her sister. So, although she does imply that there were things done, and that's what I think is interesting, because she says that Post took advantage of her sister and the other people did. So there's almost an acknowledgement there of some of the things the state was trying to keep out. So I don't know. Like I said, there's going to be more to this. I guarantee it. I think the appellate court will have a lot to say about this stuff, and I think we're going to see things. We're going to see this case back again, I think. But anyways, guys, there it is. So I'm going to send you guys over to the Simontilli trial, and I'll talk to you soon.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm. United and free. United and free. United and free.